For item number 50, Your Lordship, we have filed one affidavit in reply, Your Lordship. Petition. I'm appearing for the item, the content of address site. I have to mention the item number 20. The Rakesh Dubey is in bereavement of his father was expired. Kindly adjourn the matter to
20. 20. Who's bereavement?
the Rakesh Dubey.
It has been submitted that the counsel appearing on behalf of the respondent number 4 is in bereavement, and as such, the matter be adjourned. Puts accordingly list this matter again on 9th of September. Next.
I would like to mention for listing of a repetition for minor. It's a cooperative society matter, minor.
When?
Friday, minor.
Lordship, with the consent of the other side, I'd like to mention item number 13 to 15.
30?
To 15.
30 to 13 to 15.
1, 3, 13 to 15.
Yes. Why?
Lordship, my senior had to go Bangalore for some urgent matter.
Huh?
Difficulty, so he had to go to Itan.
Which senior?
I told him.
So what? I don't grant adjournment on senior advocates. Nothing doing.
Supplementarily, section number 51, procedural.
This is Lordship. Lordship, we have filed our wakalatnama today itself. So our names were not reflected in the cause list. So we want to withdraw this wakalatnama as some prayers were missing in the previous one.
Withdraw the,
We withdraw the writ petition, Lordship.
you filed the wakalatnama. You filed or not?
Yes, yes.
What's your name?
Improva Bitala.
Unsolved. It's D. Ghosh. What's your name?
Improva Bitala. H. Bitala.
Your name?
My name is not reflected there, Lordship. My senior is
Where is your senior?
in another court.
I don't give adjournment unless I see that their names are reflected.
We want to withdraw this.
Understood.
After some time, let this matter be taken. But much more.
One promotion.
Yeah, look, citron on a. Yes, what is this?
Lordship, this is a contempt petition, Your Lordship. Here, willful and deliberate violation of order dated 24/11/2023, Your Lordship. Pass in connection of writ petition number 209 of 2021, Your Lordship. And Your Lordship, operative part at page 10, Your Lordship. Paragraph number 4, Your Lordship.
notice making it returnable on 9th of September 2024. Petitioner herein is aggrieved by the willful and alleged violation. Aggrieved by the willful and deliberate violation. The order passed by this court on 24/11/2023 in WPC number 209 of the 2021. The respondent herein is directed to file their bring on record their stand as to why the order dated 24/11/2023 has not yet been complied with.
Go to. On the last occasion, my lord, what it has asked to produce, my lord, the Indian Telegraph Act. Not damage. 10D is kindly looking.
So, prior to initiation of the proceedings, you were issued a notice. You did not file any objection. Or you filed an objection.
My
You
lord,
did not file an objection.
at the time of survey, my lord, they were decided to install the pole near my wall, my lord, the boundary wall. But now, my lord, they are erecting the poles on the middle of the land. So, my lord, entire land will be taken for them. Otherwise, I don't have any objection, my lord. If my lord poles were installed at the place where they have near the wall, my lord, at the time of survey.
Outside your boundary.
No, inside, my lord.
Earlier,
Earlier also, inside the boundaries.
now,
Now, my lord, middle of the land, they want to install the same.
who is doing it? Who is doing it?
My lord, project manager, that is respondent number 5, my lord. Not 5, my lord, 7. That is private contractor of railways.
Railway.
Yeah.
What is railway doing here?
Actually, my lord, the transmission line is for railway. Electrification for doing railway work.
Railway is a party.
Yes,
Why nobody is appearing for the railways?
five, my lord, general manager, divisional railway manager, landing and railway, my lord. 5 and 6. My lord.
So how do you bring the Telegraph Act out there?
That is, my lord,
This is under the electricity. It is brought under by the electricity. Act. But this is not done by the electricity people. Wouldn't it come under the question of acquisition in terms with the proper other procedures of law? What are they taking, the right of way or the land?
only for electrification. Only for electrification.
Understood. Are they taking the land or only the passage out there?
Passage. Not the entire, only passage. Over the land. So that our, here is a, my lord, our own house is also there. Our electric line is also there, my lord. If the poles
They are having a high tension wire.
Yes, my lord, high tension.
So how,
32
if
kV.
it is a high tension wire, how are you going to stay in underneath? You can't stay underneath a high tension wire. I think it will be a 33 kV.
132 kV transmission. 132 kV transmission.
Then how can you stay under it? Can't stay under it.
If it is near the boundary, I don't have any objection. Here,
No. If it
But the line
is,
is also-
if there is a 132 kV line going over your land, you can't stay under it. How can you stay under it? Yes, government. How are they doing it? What action means if they are having a 132 kV line,
okay,
can they be there? I don't think they can.
they cannot. Without.
So without instruction, my lord, I cannot say anything, my lord. I have to take instructions regarding that.
As of now, the poles have not been erected.
No.
I'll give you a short notice, 7 days. Get your instruction.
Lord,
Until then, status quo be maintained. Issue notice returnable by. Arikitai?
7.
7, no? By 16th of August 2024. Mr. J. Hendik, Mr. A. Bhattacharjee appears on behalf of the respondent number 1. Mr. J. Hendik appears on behalf of the respondent number 2, 3, and 4. None appears on behalf of the respondent number 5 and 6, who are the railway authorities, in spite of advance copy of the writ petition being served upon them. As regards the respondent number 7, this court, for the time being, would not like to issue any notice. First, the case of the petitioner herein is that the petitioner is, the petitioners are owners and possessors of 9 bighas of land covered by Dag number 396 of Patta number 3 of village number 1, People Pukuri, under Moza Kaki, Lonka, Hojai, in the district of Nagaon. The railway authorities had undertaken a project for construction of a 132 kV transmission line from Grid substation / Sankordev Nagar to traction substation, Lonka, with regard to the railway electrification work. It is the case of the petitioner that initially the petitioner was informed via the notice that the said land would be taken informed by a notice that the Indian Railways Department is working on the installation of 132 kV electricity wires from Sankarnagar GSS to Lanka, Sankarnagar or Sankardevnagar? Why you are writing Sankarnagar? From Sankardevnagar GSS to the Lanka railway station. And the railway department would pay compensation to the Patadas for loss caused to them for acquisition of their land, over which electricity wires will go. The petitioners were asked to submit their objections in that regard. It is the case of the petitioners that at the time when the said action, the debarkation, at the time when the survey was carried out, there was no the transmission line only passed through the boundary of the petitioner's land. However, the petitioner have been recently informed that it would pass through the entire, through the middle of the petitioner's land. It is under such circumstances the petitioners have submitted an objection to the district commissioner, Hosai, ventilating their grievances. However, as nothing has been done, the petitioner has approached this court by filing the instant writ petition. This court, upon hearing the learned counsels for the party, inquired with Mr. J. Hendig, the learned counsel appearing on behalf of the respondent numbers 2, 3, and 4, as to under what provisions the said land have been sought to be acquired. Mr. J. Hendrick, however, submitted that he would have to obtain instructions. It has been also submitted that till date, in the land of the petitioner, the poles have not yet been, the transmission line has not yet been erected. Under such circumstances, this court, while issuing a very short notice, directs the respondent numbers 2 to 6 to provide necessary instructions as to under what provisions the acquisition is being carried out, and also as regards the allegations so made in the petition. The respondent numbers, it has also been submitted that the petitioner, by the counsel for the petitioner, that the respondent number 5 and 6 is normally represented by the central government standing council. Taking into account that they have not appeared, this court directs the counsel for the petitioner to serve copies of the writ petition, extra copies of the writ petition to the central government standing council, so that the due information, so that the this court is apprised of the instructions so sought for. আগতে এইটোত লিখিছো নহয়, Mr. J. Hendig, so and so, extra copies to লিখিছো during the course of the day.
Lordship, kindly see the page 13. They have stated that
This court
Uday
further
Naga-
directs এইটো কৰিলে status quo. দেখা নাই ন? This court in the further directs that till the next date, the status quo as regards the land of the petitioner shall be maintained. Yes.
kindly turn to the page 13, Lordship, that para 1, Lordship, they have stated, my lord, Huzai Naga. Who is this land has been, my lord, situated?
I think Hosai, it is not.
They have stated in the Naga, and a circle officer also given in Naga, Lordship, from whom I have to obtain instruction for respond number 4.
No, from page 22, it is Hosai.
page 22, the notice issued by additional deputy commissioner Hojai.
Whom he has made party?
My lord,
DC whom?
This in Huzai.
Hojai.
So find it.
And the circle officer has written Nogam.
Very well. Ask both. Circle officer is also a party. Ask both.
Not he.
Yes, what is this?
My lord, challenging the notification number 9 of 2023, your lordship, whereby my lord, order passed under section 73, it was extended. Similar matters are being taken by this honorable court.
What you are challenging?
Challenging the notification and order passed under section 73. Notification that you also will find at page,
No, where are you challenging? You're not challenging the notification under 73.
notification.
Where are you challenging? So notification 9.
Annexer page 46, your lordship.
Then what is wrong with it?
My lord, whereby my lord, the order passed under section 73 of the AGS CGST, it was extended, your lordship. In addition to that, we are challenging the summary so cause notice and order under section 73 that was issued without signature, your lordship. Different high-
Without?
signature, my lord.
Of whose?
The person who has issued, there is no digital signature. my lord.
Where?
Then you also will see page 28. Page 29, my lord, kindly see. Name is there, but signature is not there. Page 29. And order, my lord, kindly see
Summary of the so cause.
summary of it. It is given with along with one of determination of tax notice. my lord.
Then?
So cause notice is required to be served under subsection 1 of section 73. That was not given to us. Page 38 is the order passed under section 73. Here also you also will find,
Summary of the so cause notice. It is clearly written out there in bold letters.
my lord, but
Then-
there is no signature of the person who has issued it.
Have given it like this. They must have issued it. Why will they
It is
give it without
uploaded-
notice?
It is uploaded in the portal and the different high court says, my lord, on this aspect,
What?
that without signature, it amounts to, my lord, nonest in the eye of law.
When? When did different high courts say?
My lord, it was said in 2024, my lord, Andhra Pradesh High Court,
Show me.
and that notification, my lord, is you also, my lord.
No, I have not. I am not done with
So
that.
far signature part, my lord.
That notification, I have not touched it. 9, I have not touched it, taking into
Nothing.
account that 9 is preceded by a recommendation of the GST Council.
My lord, 56 was, my lord, in respect of 18, 19 and 19, 20. And 9 is in respect of 78.
Understood, but 9 is preceded by a recommendation of the GST Council, which is however not there in 56. That is the difference. And if you go to the Kerala High Court judgment as well as the judgment out there when 9 has been taken and says that it has been done rightly, why should this court at all consider? Yes, what is this?
My lord, Para 4, your lordship, may kindly see.
The essence of the name is in the present case is this, the proceeding does not contain the signature. So here the same are required to be that's why
Conclusion, Para 7, your lordship.
of the language.
After examining, my lord,
Then what did you do pursuant to that?
My lord, they have, as per subsection one of section 73, my lord, so cause notice was required to be served. That has not been done, my lord. Summary of so cause notice, my lord, they have issued along with the determination of tax. No opportunity was given to me to, my lord, reply to the, my lord, allegations mentioned. There is
Huh?
no, as per subsection one, my lord, authorities are required to so cause me as to why the tax should not be imposed, my lord, upon me. There is no so cause notice, my lord. This is summary of so cause notice issued along with determination of tax. That opportunity was not given to me to reply to the so cause notice, your honor.
No, but it is written clearly that it is a so-called notice.
Summary of so cause.
Then
What you will see.
what is else is
Some-
required?
This is summary of so cause notice. There is no mention that I have to give reply or something like that. This is given after determination of tax, my lord. Then what will be left, your lordship? First, given after
It
determining.
clearly says details of the hearing and due date of to file reply, date by which reply has to be
My
submitted
lord, there is
28/10.
Attached, but there is no so cause notice.
Huh?
Page
There is so
29, your lordship will see.
So it must have been there in the internet. You,
My lord,
if it is attached means it is there in your portal.
my lord, but
then-
there is nothing, your lordship. This is,
So
I have taken. this-
have you informed that I have not received the attachment to the?
Thereafter, they have passed order, my lord, under section 73, your lordship.
No. Did you inform when you got it in your portal?
But I specifically, my lord, I have.
Where have you said that I have not received the so-called notice to the authorities?
That
Read court is not just for coming out there, walking out there in the read court, we file a writ petition. 226 is just to be exercised at the drop of the hat.
I'm doing very well, my lord. I tried to go through, it, my lord.
Then where is it that you have
That
approached
is
the
statement
authorities and
required.
said, look here, I have received something, but there is no so-called notice attached. Where is it?
But in fact, my lord, so far as notification 9, my lord,
Because this is in the portal. It is given in the portal. It is not an order by which it is to be given out there. How can they put in the portal, you put the signature?
digital signature they can, my lord.
Huh?
There is a provision, digital signature is required to be given, my lord.
Let us see the GST.
169, your lordship will see section. In Bombay High Court also, my lord, after considering section 169,
Hello. 169.
service of notice in certain circumstances.
Any decision, order, summons, notice, or other communications under this act or rules made thereunder shall be served by one of the following: by giving or tendering it directly by a messenger, by registered post, by sent up to his email address provided at the time of registration. You got it in your email address.
On portal, your lord.
Huh?
They uploaded
You
in
got
the
it
portal.
not in the portal. You must have got it by your email
My
address.
lord, subsequently they have written regarding portal also,
Where?
by giving printing guide.
For publication on the newspaper, making it on the common portal. On the common portal, you got it. And then there was no, because you don't require this to be signed. You require only the so-called notice to be signed. Whether the so-called notice was digitally signed is the question where there is no attachment or not. How do I find out?
But specifically, I have taken, my lord. In the-
No. First, you should have informed them. This was given on 28/9/2023. Almost 1 year is about to go. Why should we interfere at all?
And lordship, date of submission.
Because if I issue a notice in these type of cases, he will take time for another 1 year, which makes it 2 years. Tell me,
Instruction I have to obtain, my lord, whether, but in
that
the.
is the only instruction. When it is there in the common portal and said that there is a bear attached, so it has to be You must have said out there whether it was there or not. And if it was not there, why haven't you asked them? If it was available out there. No. Writ petition is not to me, it's to the High Court. Writ petition is not before that authority. How will the authority know? And when was this passed? This order attachment to the determination of tax?
Asked my lord. On the same day, it was with the notice, your lordship, 28/9/2023.
Huh?
28/9/2023.
How do I know?
Given along with the, my lord, determination under rule 142(1)A, your lordship will see. This was issued under rule 148(A)(1).
What attachment to determination? You have filed your annual on examination of ERA and other regard. It is found that you have not declared your correct tax liability while filing the annual returns. The summary under the ERA is declared as so and so. The excess claim of ITC. Under 16(2)(c), every person shall be entitled to take credit on the supply on his amount of not correctly availed input tax on his inward so and so. Then ITC under so and so, so and so, so and so. Under section 17(1) and 2, where the goods or services or goods are grouping so and so, so and so. Under section 17(5) of the input tax shall not be availed under ITC in the GST and other details SD proper officers.
In fact, in page 38, my lord.
Then everything is being given
My lord,
attachment
38.
to DRC. What is DRC? You have filed, this is for 2 years.
My page 38, your lordship, can you see?
Huh?
Page 38, my lord, 38.
Yes. There are 2 notices.
Order under section 73.
Where?
Page 38, my lord, can you see?
This was passed after 3 months. As
They are
per-
saying about so-called notice, but there is no date, nothing, your lordship. A
Where?
so-called notice, your order under section 73. Thereafter they are writing, my lord, a so-called notice statement referred to above was issued to you under section 73 Act for the reasons stated therein.
Where? So-called notice, yes.
Since no payment has been made within 30 days of the issue of the notice by you, therefore, on the basis of the documents available with the department and information furnished by you, if any demand is created for the regions and other details attached in annexure. Please note
This
that,
was passed on 25/12/2023. Now
Yeah.
what do you want?
my lord, they are discussing about so-called notice.
What do you want now?
Lord, I want that since so-called notice was not given, or your lordship may,
No. So-called notice was given.
my lord, matter may be remanded, I will,
No, nothing doing. How do I demand it unless I find that there was no so-called notice given?
so let the instruction maybe, I will also obtain the instruction from the
Yes.
department also.
Get an instruction next week. And no stay business in all these things. But if you don't get your instruction, then stay becomes.
Yes,
automatic. Heard Mr. A. Goyal, the learned counsel, appearing on behalf of the petitioner. Mr. B. Chaudhary appears on behalf of the respondent numbers 1, 2, and 3. Taking into account that the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon them during the course of the day. Issue notice to issue notice making it returnable on 16th of August 2024. The grievance of the petitioner in the instant proceedings is that are twofold. First, that the petitioner was not issued a show cause notice prior to passing of an order under section 73(9) of the PGST Act of the Assam of the AGST Act, Assam
Goods and service.
Goods and Service Tax Act 2017. It is also the case of the petitioner that the notices which have notice and the order which have been passed is also not signed by the person, officer duly authorized to do so. The learned counsel for the petitioner further submitted that there is not even a digital signature. On the returnable date, Mr. B. Chaudhary shall obtain the necessary instructions as to whether the petitioner was issued a notice, show cause notice? And if so, in what manner? In addition to that, Mr. B. Chaudhary shall also obtain instruction as to whether the original order so passed under section 73(9) of the AGST Act 2017 has been duly signed. The records pertaining to the said orders also be placed before this court on the next date. Interim orders shall be considered on the next date.
In the item number 4, your lordship, apart from issue which I have placed before your lordship, central CGST has already taken over the matter. And we have page 38, my lord. Can you see?
Wait,
Fine.
let us look. Yes, what is this same party?
Different party.
Okay, then,
In this matter, apart from the ground which I have taken in the earlier matter, in this matter, page 38, your lordship will see.
yes.
Like the proposed notice we have given, my lord.
Hmm.
If in reference to the above communication, the undersigned most humbly submits that so CGST has initiated proceeding of inquiry in 2022 and determination of tax regarding output liability eligible items.
Is this your reply?
My lord, because in the portal, my lord, there is a space, my lord. I have to write in that space only.
Understood. This is your reply.
What I can do,
No, no, I'm asking.
my reply.
Where is your signature?
Signature of authorized signatory.
Where is the signature? No. Well,
Same.
this answer, this matter was, if it was item number 3, it would have answered the.
They are- Portal is there, your lordship.
Then you go and file something to the effect. Then, this
So-
I can't put it. No show cause notice. You have received the show cause notice.
Here I am on that, my lord. As per.
And you have not challenged that there is no signature in the show cause notice.
My lord, in this matter, we have written, your lordship.
No,
that-
no, no. How can you write? Why did you reply? Then,
Portal is there, my lord, they are
no,
provided.
in the portal you do it.
So, my lord, as per subsection 2B, your lordship, 6, my lord, once the CGST has taken over the matter.
Now, what is your case here in this
my lord,
case?
already CGST has taken over the matter. So, state as per subsection 2A of Act, your lordship, state cannot proceed in the matter.
2A, 6.2.
My lord, that I have reproduced page 8. 6.2, your lord.
6.2. This is a case of investigation.
My-
Is
But
it a case of
already
investigation here?
Determination of tax, everything.
No, no, no. 6.2 is a question of investigation.
Where a proper
6.2
officer of
six-
central goods has initiated any proceeding,
Then,
your lordship.
then,
B, clause B, your lordship, we can see, where a proper officer.
subject to the, no, you can't come to there. Subject to the conditions specified in the notification issued under subsection 1, when officer issues an order under this act, he shall also issue an order under the Central Goods Center Act. When an proper officer under the Central Goods has initiated any proceeding on the subject matter, no proceeding shall be initiated by the proper under there on the same matter. Meaning thereby, see the heading of the section.
Subject to the conditions.
No, 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 heading. It is given in bold. You are not there. Get your book.
Authorization of officers of state tax or union territory tax or as a proper officer in certain circumstances.
Without prejudice to the provision that the officer appointed under so-and-so are authorized to be the proper for the purpose of this act, subject to such condition as the government on recommendation of the council may notify. Then where a proper officer under the state or the union territory have initiated any proceedings on the subject matter, no proceedings shall be initiated by the proper officer under this act on the same subject matter. Meaning thereby that if any proceedings have been initiated by the state government,
And the-
state officer, the central cannot. And the central has done it, state cannot. Now, if the state have already done it,
The present case, it was, your lordship will see
order
reply.
under 73 has been passed.
let the proceeding initiated by central government in the year 2020, your lordship. And state notice, your lordship,
And is the central government proceeding over?
still pending, your lordship.
Show me.
If determination of tax was, we have given reply to central government, but it is
Where? Your case come under 16.4.
timely.
Your case come under 16.4 or 16.2.
16
Then why you are filing? They are coming up with that amendment. Because you have a big problem if you file. 128A, which is coming up, says that if you have a pending writ petition or an appeal out there, the matter goes. You are on the interest and penalty. So
Because notification yet to be issued, my lord.
so what?
That will be coming up. That will be coming up, lordship, shortly.
But for my lord. Till then, your lord.
What? This is nothing. This order was passed long time. If you can save yourself for now, how did you save all your thing for all these days?
This honorable court, another coordinate bench has taken note of that notification 9 of 2023 also.
Fantastic. But the sad part is that court is not, yeah, nah? And you see, this was done at that point of time. Now we have the benefit of the Kerala judgment and the Uttar Pradesh judgment, wherein it categorically says nothing doing to that effect, and it have duly given it. Yes, you may have a case under the 56 notification, although that was subject to be taken up on 21st of August. I'll list this on 21st of August. In the meantime, you may get the notification. Your only problem is 16.4. Now it's 16.5 coming in. But the only problem is, you do one thing. Why don't you withdraw? And I give you a liberty. You can approach after, if within a particular period of time, they have not come, or because obviously the Finance Act is going to be notified very soon. If in the Finance Act there is no provision similar to Section 128A, then you are at liberty to come. I think that is a better option. Giving you a liberty for the time being. So then you can again come back if this happens. Because they have categorically mentioned in the Finance Act, I think this is a better option for you. Because if it is pending, and you see the Finance Act, Finance Act. You are also coming.
Yes, my lord, after the notification by, of the Finance Act, lordship state will have to, adopt or, come up with a subsequent notification.
Now, Section 70. 128A. Notwithstanding anything to the contrary contained in this act, where an amount of tax is payable by a person chargeable with tax with accordance with a notice under subsection 1 of Section 73 or a statement on so and so, pertaining to the period from 1st of July 2017 to 31st of Iman, or part thereof, and the said person pays the full amount of tax as per the notice or the statement of so and so as the case may be, on or before the date as may be notified by the government on the recommendation of the council, no interest under Section 50 and penalty under the act shall be payable, and all proceedings in respect of such notice or order or statement as the case may be shall be deemed to be concluded subject to such condition as may prescribe. Now kindly come to the number 3. Nothing contained in subsection 1 shall be applicable in respect of cases where an appeal or a writ petition is filed by the said person is pending before the appellate authority or appellate tribunal or a court as the case may be, and has not been withdrawn by the said person on or before the date notified under subsection 1. So let me give you a liberty to approach, and taking into account that this is a state GST, na? That his submission that they are coming up with a similar provision. Because your problem is 16.4, and then 16.5 will help you out, and thereby 70 will help you. Where is that 70? Then you get, because in the earlier case you may not get, because 16.2 is not given that exception, which is given to 16.4. Okay.
Or your lordship may take up this matter on Friday. I will also obtain instruction from client.
Okay. Anyways, till Friday, nothing is going to happen. Better off. Mr. A. Goyal, the learned counsel, appearing on behalf of the petitioner, submits that he may be granted an accommodation today. List the matter on 9/8/2000. We'll have it on 12/8/2020.
Item number same. Item number 7.
7 same.
Detail.
Yes, what is this?
May it please your lordships.
What is your case?
May it please your lordships. I beg to
Hindustan
appeal the notice.
Construction Company. Who is arguing?
May it please your lordships.
Yes, tell me.
Lordships, my lord, this petition, my lord,
Ah,
challenges the order passed by the authority, my lords.
ah.
The order is dated 30th of April 2024, which has been passed in terms of notification number 56 of 2023, extending the time limit for the financial year 18-19, my lords.
Understood, Mr.
Lordship.
Counsel, but only thing I'm aware, have you seen your affidavit? Who has filed this affidavit? Hindustan Construction Company Limited. Can there be an affidavit in this manner?
My apology, my lords. Lordships are right, my lords.
Withdraw and file a fresh one. And say who is the person who has been duly authorized. Say something on that. And then
Lordships.
let him come up and state it on the affidavit. It doesn't look nice of a affidavit of Hindustan Construction Company Limited. The learned counsel, appearing on behalf of the petitioner, submits that there is a formal defect in the affidavit so filed supporting
Lordship, I
the
will-
writ petition. He submits that he may be permitted to withdraw the instant writ petition and given liberty to refile. Accordingly, taking into account that there is a formal defect, the instant writ petition stands closed on withdrawal. However, liberty is given to refile the writ petition on the same cause of action.
Lordship pleases. Grateful. We are obligements.
Yes, what is this?
Telling the demand at page 106, my lord.
Page
106.
106.
So what happened here is that, my lord,
Wait. Let me find out. Yes, what is this?
this is a summary of order, my lord.
Ah,
Summary of so-called was issued to petitioner, my lord. Petitioner submitted his reply. And petitioner specifically requested for providing the personal opportunity of hearing, my lord. Personal hearing was requested. Now, my lord, awaiting order, my lord, this summary was uploaded in the portal without passing any order under section 73(9), my lord. I have annexed, my lord, the status of the proceeding, my lord, at page 109, my lord.
there is no order under section 73(9).
The proceeding at page 109, lord, you will see I have annexed the screenshots, my lord.
Screenshot. What is happening?
What you will see here, my lord. Status, my lord, reply fund is pending for order by tax officer.
Then this is
And lordship will see
29. When is the date of the screenshot?
in short
No date.
page 110, my lord. Below lordship will see it is a 10/5/24.
Where?
Right side below.
Okay. 10/5/2024. Then
My lord, the requirement of law is that, my lord, first the order has to be passed under section 73(9). Thereafter, summary thereof will be uploaded in the portal, my lord. That your lordship will see rule 1.
when was this order passed?
Order was passed, my lord, on
4/1/2024. And there is no order passed as per you, as on the date on which it is. Let us get his instruction.
To be an order, my lord, even if, my lord, there was a specific request by the petitioner for providing an opportunity of hearing. That has not been provided, my lord.
Then these are things which nothing to do.
My lord.
We will only inquire as to whether an order has been passed. No stay business. You,
Inspection lordship fixed on Monday, they may obtain instructions, my lord.
Huh?
Lordship fixed on Monday, they may obtain instructions, whether order was.
16th, he has to get some time.
Otherwise, my lord, section 75, subsection 4, my lord, which says, if any authority is contemplating or passing an adverse order, they must give an opportunity of hearing. So it is a mandate of law, man, section 75, subsection 4, my lord.
Whether hearing has been given or not, how do I know?
Statement, my lord.
You made a statement but you have made a statement after 8 months.
Paragraph,
Your order was passed on 4/1/2024. You made a statement after 8 months. Today, by filing the writ petition. Yes. No. You have made a statement on 29th of July 2024. That is the date of your affidavit. Earlier to that, where have you made a statement that you have passed an order without giving me an opportunity? Why were you sleeping all this while?
my lord, at page number 103, my lord.
What? When did you issue this? Where? What is the date of this communication? No date.
It was sent
5/6.
by post was sent.
5/6/2024. Then, after the order was passed on 4/1/2024.
This order we got to know on 2nd of.
So thereafter, you are asking for an opportunity of hearing.
Lordship will see, I have made a statement in paragraph 11, my lord.
Forget about the 11. You are asking for an opportunity of hearing when? We are in receipt of the letter dated. However, till today, no hearing has been scheduled. We request to grant an opportunity after the order has been passed on 4/1.
It was a summary demand.
GST liability notice came out on 4/1/2024. Did you ask them? This is the order you are challenging, 106. Are you not? This order is of 4/1/2024. It must have been put in the portal. You are you have done it very properly of putting getting screenshot of this portal. So this means that you closely monitor the portal.
I have approached, my lord. There is no order at all.
Let us see. We ask only them as to whether there is an order. Notice making it returnable on 16th of August 2020. It's the G.B. Chaudhary appears on behalf of the respondent number 1, 2, and 3 and accepts notice. Extra copies of the writ petition be served during the course of the day. The case of the petitioner herein is that the respondent authorities have the case of the petitioner herein is that the respondent authority, respondent number 3, have issued the summary of the order dated 4/1/2024 without passing any order under section 73(9) of the GST AGST Act 2017. It is a further case of the petitioner that the petitioner have sought for an opportunity of hearing. However, without giving that opportunity, the order, summary of the order have been passed. First, taking into account the limited scope on which the incident with petition has been filed, Mr. B. Chaudhary shall obtain the instructions as to whether the order under section 73(9) of the AGST Act 2017 have been passed, and whether any opportunity of hearing was sought for by the petitioner prior to the passing of the said order, and in bracket, comma, bracket, if any, said order, if any, and if so, whether any opportunity of hearing was given.
I'm praying for some protection, my lord.
What?
No persuasion. Kindly observe, interim may be considered on that date.
The interim order shall be considered in
Strictly obliged, my lord. Eight.
Yes, Mr. Counsel, what is this?
Interim order, your lordship. Annex of 5, page 25. What happened, your lordship? I have been allotted a shop
Stepping aside the notice.
at Tinali Bazar, which is under the Anchalik Panchayat. And this entire
Which
bazar.
notice?
Yes,
Notice for removal of unauthorized occupation.
yes.
By whom? National Highway Authority. Then?
My shop, in fact, the entire bazaar is situated beyond the land belonging to highway. Highway was constructed long back in 2008.
Hmm.
Thereafter, there is a footpath, then passenger rest seat. And beyond that, beyond 30 meters is the entire bazaar, including my shop. And what? Due to some person enemical to me who have not been allotted bazaar, they made some complaint. And it has been in fact reflected in the notice here, may kindly see, page 25. Whereas I, Anant Lal, on periodical inspection of the highway land on the information received by me and satisfied by an unauthorized occupation has taken place on so and so and so. You comprise of area, length 16 meters, wide 20 meters, situated at KM 32+00, left-hand side of National Highway so and so, and as such unauthorized occupation been caused by you, and you are responsible for so and so. Therefore, you are, you take notice that you are hereby required to remove the unauthorized occupation within 7 days from the date of receipt of the notice served on you. You may make representation within 3 days. I made within 2 days. Their representation is pending. Annex 6 is my.
Then?
Annex 6 is my representation.
Yes,
It's
ready,
good.
ready. I'm
Good.
ready. Now tell me. What is the next course of action?
They have directed me to file a representation. I have
You
filed it.
submitted.
Yes.
Then they are to, did you ask for hearing?
Yes, already there.
No, no. Did you ask for hearing?
That
3
also-
days from the date on which the notice is served, indicate the designation and address of the
Yes.
officer to whom representation is to be made, and such, if any, shall be heard
Shall be
on.
heard.
Ah.
Yes,
So, that will be heard by you. Let them hear it.
There's one aspect I would like to bring to your
Yeah.
notice. Page 16, my lord. Page 16 of the writ petition. The annex to one, page 16. The allotment that was granted to the petitioner by the Anchalik Panchayat as pleaded by him was for a period of 1 year.
1 year.
1 year. So it ended on 30th of June 2024. So
Hmm.
as on today, my lord, his very locus is questionable.
no,
And
that,
he has not even stated that if he has been granted any extension or not.
yes, I have stated there, there are,
No, 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 no. Extension will be obviously on the basis of some document.
He has not annexed anything as such on a bare perusal.
no, what happened, your lordship, may kindly see,
The settlement period. is-
Anyway, Mr. Counsel,
Yeah.
whatever may be, proceedings have been initiated by the NHAI. Once NHAI does it, he has submitted his representation, let the NHAI hear it. Why should this court interfere with all these things? And go into that question and thereby bring up an issue which gives this court that I'll keep the litigation and give a stay. Is it in the interest?
No, but not saying his shop is within the right of way of the highway.
Okay,
Right of
maybe.
way.
You dispose it of. He has submitted a representation, you give him a hearing. When do you want the hearing? Well, give a date. Tomorrow.
Let be on next Monday.
He will appear before your officer. Who is that officer?
Project respondent number 2.
Respondent number 2. Where is his office? So he will appear with project director at 10:30 AM. And thereupon the project director, let him hear. Let him hear his representation and then dispose. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss N. S. What is your name? Again forget. R.
P handing for Panchayat. P handing for Panchayat. Yeah.
So-and-so appears on behalf of the respondent numbers 1 and 2.
I need to.
Huh?
Arbor.
Arbora appears for respondent number 1 and 2. P. Bodley. What is his name?
P handing.
P. Hendick
Four
appears
and
on behalf of the respondent number 3 and 4
6, 7.
and 6.
4, 6, and 7.
3?
3 government.
Why principal
Three,
secretary or a panchayat will
3, 4, 6, and 7.
3, 4, 6
And
and 7. Mr. G. Hendick appears on behalf of the respondent number 5. Taking into account the scope of the petition, this court is of the opinion that the ends of justice would meet if the instant writ petition is disposed of at the motion stage itself. Accordingly, this court duly heard the learned counsels appearing on behalf of the parties to the proceedings. The petitioner herein was allotted a plot by the Udali Anchalik Panchayat for a period of 1 year with effect from 1st of July 2023 to 30th of June 2024. It has been submitted that the said plot that there has been an extension so granted, although no documents could be filed. On 27/7/2024, a notice was issued by the respondent number 2. Respondent number 2 under the National Highway (Land and Traffic Act 2002, whereby it was informed to the petitioner that on periodical inspection of the highway land, it was found that the petitioner have unauthorizedly encroached and is in unauthorized occupation and as such, a notice was issued asking the petitioner to submit their representation within 3 days and also to indicate a place of hearing. Pursuant to the said notice, the petitioner duly submitted the representation on 29/7/2024. The petitioner apprehends that without giving any hearing to the petitioner, the respondent numbers 1 and 2 shall take action for the respondent authorities may take action to evict the petitioner. And it is under such circumstances the writ petition has been filed. Mr. P. Hendick, the learned counsel appearing on behalf of the PNRD department, submits that the petitioner's right over the land have already ceased, taking into account that the allotment order which was issued and made a part of the representation have already expired on 30/6/2024. And as such, the petitioner has no conceivable right to remain in possession or in unauthorized occupation of the land. Ms. Arbora, appearing on behalf of the respondent numbers 1 and 2, submits that the petitioner is in unauthorized occupation of the right of way, and as such, the said notice have been issued. This court, upon hearing the learned counsels appearing on behalf of the parties and taking into account the National Highway Land and Traffic Clause Act 2002, which provides a due and provides an effective and efficacious remedy, which provides a due procedure as to how an unauthorized provides a due procedure as to how an unauthorized occupant can be removed. And the petitioner, having already been issued a notice and the petitioner have submitted a representation, is of the opinion that the interest of justice is met if the petitioner is given a hearing prior to passing any order under the said Act of 2002. Under such circumstances, this court asks the counsels appearing on behalf of the petitioner as well as the respondent number 1 and 2 as to when the petitioner would appear before the respondent number 2. It has been submitted that the petitioner would be appearing on 12/8/2024 at 10:30 a.m. before the respondent number 2 for the hearing. Under such circumstances, this court therefore directs the respondent number 2 to carry out the hearing on 12/8/2024 at 10:30 a.m. or such other time as may be convenient to the respondent number 2, and thereupon proceed in accordance with the provisions of the Act of 2002. What? It's directed that till the representation of the petitioner is not disposed of, the respondent number 2 shall not take any steps for eviction of the petitioner.
All right. In fact, I have been single out here. The others of the
You have been singled out because your allotment has expired.
everyone allotment has expected because Anjali has been dissolved, The matter has been dissolved throughout the state of Assam. And now it is run by the executive monitoring committee,
You have no right.
That statement I have made,
Unless you have a right, how do you? Anyways, let us not go into such nitty-gritties today. Some other day.
In this case, my lord, the petitioner, my lord, before his lawsuit was limited, clear lawsuit was prepared.
What is this limited? The moment you say it to be limited, I fear more.
So, my lord, filed a writ petition before in this honorable court lawsuit in that case.
Partition application submitted by respondent number 6 and further not to pass an order until WBC is finally decided. What?
Partition proceeding lawsuit.
Then?
My lord, partition proceeding lawsuit. I filed a writ petition in the honorable high court lawsuit. In that case, my notice has been issued lawsuit. The fact of the case, in that case, my lord, the reviewing authority, my lord, despite my submission of the application for my lord, the mutation, my lord, on the right of inheritance lawsuit, my father's property lawsuit. That has not been, my lord, decided, my lord, sitting about the matter, my lord, saying that the tag numbers are, my lord, something problem lawsuit, submitted application.
You say that you are the owner of the land.
Yes, lordship, as the right of inheritance, we are possessor, lordship.
Are you the owner of the land?
Yes, lordship, as the right of.
Fantastic. If you are the owner of the land, why are you taking the pain of filing two petitions?
My lord, that is defined cause of action, lordship. Now, this.
Why are you filing this petition?
My lord, that is why I am submitting, lordship. May I-
Go to the civil court, file a suit. The moment
Yes,
you
pending, lordship.
miss, huh? The moment the suit is being filed and inform the revenue authority, why you need this court to interfere? Once the issue as regards title is pending, the deputy commissioner cannot go for a partition. That is the law.
Section, my lord, 100 lordship of the land revenue regulation.
Did you raise that issue before the deputy commissioner?
My lord, I submitted application, objection was submitted before the deputy commissioner saying that the, against my lord, mutation, disposal of the mutation application, we submitted hybrid petition. in the High Court,
I'm
and
not
that is
on
pending.
mutation.
So,
Mr. Is it against the mutation or a partition?
this petition was against partition was.
Partition who filed?
That's one number 6.
He wants a partition of his land.
Well, he wants partition, I want mutation was.
Your mutation is different. I have nothing to do with your mutation. He wants a partition. Now, you say, why is it partition not entitled to? Tell me.
My lord, partition, until my lord mutation application is decided, lordship. My lord, my share, my name is my lord mutated in place of my father, late father, lordship. So partition is my lord, cannot be done, my lord. If it is done, lordship, the property is partition, lordship. His share may be disposed of, lordship. Then in that event, lordship, I will be in trouble, lordship. Now kindly see, objection petition kindly, that is at page 53.
Eight?
Page 53.
Yes.
My lord, that was submitted, lordship.
Guwahati High Court objected to the sale of the land of the said detail. What is the subject?
Not objected, lordship.
You say
Application
out there,
humbly
page
submit that
53,
in the application number.
the subject, the Guwahati High Court objected to the sale of the land of the said detail. What is this? Sir, applicant humbly submit that the case of Iman is pending in the High Court in respect of so and so. What? Tapasil deeded land. In such circumstance, the open party has applied to the office for transfer of the land inscribed in the case and is about to sell the land. The Dhakwakana case circle has already stayed the application with petition. The office has got the order prepared, therefore will suffer if the land is transferred to another.
My lord, Banagar is at page
Right?
56.
What is this? Is this against an application for granting permission or is it against a partition?
Against partition law.
What is the ground of partition is what? You object to the partition saying that you see, I am the owner of the land and as such, and dispute his title for a partition. And then the deputy commissioner has to resort to section 100. Is this the type of application you file? Okay, now tell me how much is the cost for unnecessarily spoiling time?
Application law.
How much
lordship.
cost
My
on
lord,
you or your client? Unnecessarily filing this.
It's not filed, it's the application law.
No, nothing. These are cases to be dismissed with cost. What?
That may be dear laws.
Petitioner, no, you have advised the petitioner to come. You should have, you are a great civil lawyer. So you should have told him that go under 100.
Lordship, at least it's section 99 lordship.
99
Section
says what?
99 of the land revenue
There,
regulation.
what does it say?
Lordship, section 99 lordship, notification of application lordship. My lord, bear it lordship. The deputy commissioner shall, if the application is in the order and not on open to objection on the face of it, publish a proclamation at his office and at some conspicuous place on the estate to which the application state relates, and shall serve a notice on all sorts of the recorded proprietors or landholders of the estate as have not joined in the application, declaring any of them in possession who may object to the partition to appear before him and state their objections on a day to be specified in the.
Yes, now,
proclamation.
Mr. Counsel, are you withdrawing or should I dismiss? Which one do you want? Give you the option.
My lord, what I'm
Which
submitting,
one?
section 100 lordship. The deputy
100 I
commissioner,
know.
my lord, may My lord,
If-
stay.
To my knowledge, what is 100, I know. And if you have, I'm putting it out there in the order. If you have any quarrel, there's a division bench. Chalo.
Then my lord, one, my lord, I may submit one.
What?
My
What?
lord, I may be given on liberty to file appropriate application lawsuit. My lord.
Oh, who has asked you not to?
That observation, my lord, that observation might be
Okay.
given, my lord. that-
Mr. M.H. Ahmed. The learned counsel appearing on behalf of, huh?
My lord, that observation, I would be allowed to.
Yes. Submits. Now, heard Mr. M.H. Ahmed, the learned counsel appearing on behalf of the petitioner. Mr. Evachaji appears for the respondent number 1. Mr. J. Hendig appears for respondent number 2, 3, 4, and 5. Full stop. Taking into account the order which this court proposes to pass in the instant proceeding, the issuance of notice upon the respondent number 6 is dispensed with. Full stop. The petitioner herein has filed the instant petition for stalling the partition proceedings pending before the district commissioner, Lakhimpur, filed by the respondent number 6. This court, the reason why the petitioner 6 has approached this court, the reason for approaching this court is that the petitioner's mutation application is pending. And as such, in absence of the decision in the mutation application, a partition is carried out, the petitioner would be affected. This court have also taken note of the objection which have been filed by the petitioner before the district commissioner, Lakhimpur. The said objection, however, does not seem to be in consonance with the provisions of Section 100 of the Assam Land and Revenue Regulation 1886. The learned counsel appearing on behalf of the petitioner submits that the petitioner has right over the land wherein the partition have been sought. If that be so, this court fails to understand why the petitioner have not filed any application bringing to the attention of the district commissioner Lakhimpur, before whom the partition proceedings is pending, as regards the objection while raising objection to the partition proceedings. It being a well-settled principle of law that if there is a dispute as regards the title over the property, a partition proceed, the revenue authority has to relegate the parties to the civil court. Under such circumstances, this court is not interfering and this court does not feel that this is a fit case for entertaining the instant petition under Article 2 to 6 of the Constitution. And accordingly, the petition stands dismissed. However, the petitioner is always at liberty to approach the district commissioner Lakhimpur and file objection in respect to the partition proceedings within the ambit of law.
My lord,
I gave you
my
more
lord,
than
clause
what you
may
want.
be added, my lord.
What?
Instead of dismiss clause, clause may be.
Okay. In addition to that, for unnecessarily filing, a cost of 15,000
My
is due.
lord,
You want that?
my lord, that's not correct.
Dismiss to dismiss.
My lord, cost.
In pursuance to the permission granted to me, my lord, and I have erected the boundary wall, my lord. Thereafter, my lord, respondent number 2 issued me a notice, my lord, show cause notice, without supplying me the copies of the petition, my lord. And issued the impine
Which
order.
order you are challenging?
I am challenging, my lord, page 47.
Yes, then
My lord, I have erected my boundary wall in pursuance to the permission that your lordship will see at page 41 and 42.
this one, page 41,
41, this is my permission, my
is the permission for boundary wall?
lord. It is a boundary wall.
Where?
Top, my lord, in the box, boundary wall.
Hmm.
Type of construction, just below that. Plans. East, west, south, my lord, it has been fine, my lord. And white,
So you have a permission for boundary wall.
fine.
Then
Thereafter, my lord, a complaint, I have been received a notice on page 43. 43, my lord. Then I have replied at page 44. Thereafter, my lord, 44, my lord, 45, again, I have been asked to, my lord, to attend a particular day of hearing, my lord. Accordingly, my lord, with the help of my employee, I sought for an adjournment saying that, my lord, I am out of state.
Then
That, my lord, lordship will see page 46. I have duly intimated that due to my business purpose, so I sought for adjournment. Thereafter, my lord, without considering anything, my lord, page 47 is the in order by the respondent number 2 as a chairman.
then what happened?
My lord, respondent number 2 has issued the in order at page 47.
I'm giving you 7 days time.
7 days time.
7 days time is over.
No, my lord, I have received, my lord, on 29, my lord. Immediately after receiving it, my lord, I have filed instant writ petition.
So what is your allegation?
Allegation is that, my lord, that whatever it is there, my lord, I have erected and persons to my permission within my compound.
No, how can this court find out? So should I go there?
No, my
What?
lord, not that,
How?
my lord.
Tell me,
My lord,
how
if-
will the court
if
find
the-
out as to
if the, my
whether
lord, authority,
you have encroached 0.87 meters
My
on
lord.
the eastern side?
my lord, eastern side, my lord, I have already in my boundary, I cannot go there. Whatever erected, I have done in persons to my permission. Nothing beyond that. And now, my lord, they did not serve me a copy of the complaint petition also, my. And I asked for a simple adjournment, just give me some date, my. What
But
is the,
if you have not been submitted a complaint copy, then
But-
why did you write that the complainant have filed a false and vexatious complaint against me in order to defend?
information, basing on information?
You have not mentioned in your so-called reply.
From the show cause they are saying, my.
You are saying out here, that's not the complainant have filed.
One complaint, page 43, my. It is the first show cause they have issued.
You did not ask for the complaint.
I asked, I have made
Where?
a categorical statement, my.
No categorical statement here. Where did you ask there?
I asked there, my lord, right now this copy is,
No,
maybe some copies are with me, my lord.
show me where you asked
There.
that you should be given.
Just a minute, my lord. Recently also I have asked for the copy, my. Copy, सुनिए। तीन बार सुनिए, किसी को तुम्हारे।
Simply won't do. Then
My lord, My lord,
Even at the time of hearing, when you are seeking an adjournment also, you did not ask.
my lord.
Why?
Thereafter, my lord, I have asked, I have applied RTI also, my lord. They are reluctant to give me, my lord, any copy. That copy is with me at my mobile. The recent copy, my lord, they have applied. That copy is also there with me,
For what?
seeking copies.
Of? Taking copy of what? The
Seeking
complaint.
copies of the complaint.
So what?
Other
You
relevant
never
document.
asked anybody at any point of time that you require a copy. You are asking under the RTI later on. Seems to be an afterthought.
Without copy, my lord, I am made a categorical statement.
Did you inquire what happened on 25/9, 29/9, 29/6?
29, my lord, 9, my lord, I asked for the adjournment.
Then what happened?
Then, my lord, nothing had happened, my lord. Then, my lord, straight away they passed the implement.
What happened on 29/6? That was the date fixed. There should have been some order passed.
My lord, that copies with the authority. That I cannot have access.
You must have inquired.
I inquired, my lord, they are
Was
not
the
allowing me
time
to.
granted or not?
My lord, no.
How do you know?
My lord, my client instructed me, my lord.
So
No
time was not granted.
No, time was not.
So then why didn't you approach immediately?
My lord,
Why didn't you approach immediately before the school?
my lord,
The
I
time
was
not
out
granted.
of station, my
Why
lord.
did
Then
you
I
wait for
received
the order to be passed?
my lord, I received the impin order, then immediately I approached.
Understood. Why? Why not prior to that? The order was passed after a long time, 25/7.
22/7.
25/7. See the signature.
Order, my lord, 22/7.
22/7, but signed on 25/7.
My lord.
Why were you waiting for 22 days or
My lord,
25
I
days?
thought, my lord, adjournment will be given and they will ask
So
me.
that, but you knew that adjournment was not given. You said by yourself now.
My lord,
Then,
adjournment was not given, my lord. I
so
thought,
then
my
why
lord,
didn't you
they-
approach? That you see, lack of natural justice, I should have been heard or something. Then
my lord, I know, my lord, they will give me some notice again, my lord, for appearing or again.
Why?
Since I have asked
on one hand, you say that the adjournment was not granted.
adjournment, my lord, is from the impin order, it is presumed, my lord, I was not considered. From the impin order, it reveals, my lord, my adjournment was not given. Because, my lord,
Now you have come to learn.
yes, my lordship will
Yeah,
see,
after getting the impugn order,
my lord, after coming to the impin
not
order,
earlier.
after coming to the impin order, my lord.
So therefore, I was putting you a question, what happened on 29/6?
On 29/6, my lord,
You just gave the paper and came back,
I gave a paper through my staff, then I
and you came back,
came back.
and you never inquired thereafter.
My lord, I thought, my lord, I'll receive some notice, my lord. In further course of hearing, my lord, they will issue me notice. That has not been done.
And what about the appeal?
Appeal, my lord, I have checked, my lord, it cannot. Lordship will see, it says something different, my lord. If your lordship permit me, I'll just read out, my lord, section 42. That says, my lord, in case of any, my lord, any person agree by the decision of the authority in respect of compensation and betterment,
Some municipal act.
this book,
What is that book?
that is the Assam Town and Country Planning Act 1959. That
This
was,
is done by whom? Municipal body?
yes, my lord,
Let us go by the
Development
municipal-
Authority,
No, this power is being exercised by the municipal act,
my
not
lord.
the town and county planning.
It has been accessed by the Silchar Development Authority.
No, it is done by the municipal, under the municipal act.
Impin order reveals, my lord, Chairman, Silchar Development Authority.
Huh?
Silchar Development Authority.
Town and county planning act.
Office of the Chairman, Silchar Development Authority.
Development authority. So this is under the,
This comes under, my lord, Assam Town
Very
and
good,
Country Planning Act 1959.
this is not under the municipality.
Lordship can have a look, my book, my lord, I have flagged some.
Where is the power to demolish?
Demolish, my lord, from the imping order, it reveals
Where?
section
Where is the-
13,
Where is the power to demolish?
13, my lord. From the imping order, it reveals. 13, 13A, 13B, 13(4). 13 and 30B, 30B 1, 2, 3. 30.
So they exercise the powers on 13(4)(a).
13(4)(a) and 30B also. B 1, 2, 3, they said from the imping order. It been, my lord, demarcation. Then, my lord, law will take its own. Yeah.
Heard Mr. J.L. Balbunia, the learned counsel appearing on behalf of the petitioner. Notice making it returnable by 11th of September 2024. Mr. J. Hendrik appears on behalf of the respondent number 1.
One in,
One on
one only.
as regard and accepts notice and he was to extra copy of the petition be served upon him during the course of the day. As regards the respondent number 2, 3, and 4, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. In addition to that, the petitioner is also directed to take effect service upon the respondent number 2, 3, and 4 by way of dusty routed through the registry of this court and file an affidavit of service as regards the respondent number 2, 3, and 4. The petitioner, the case of the petitioner herein is that the petitioner, pursuant to purchase of a plot of land, obtained the permission for construction of a boundary wall, which was duly granted by the Fishery Development Authority on 8/2/2024. Subsequent thereto, the petitioner started constructing the wall. On 17/5/2024, Chairman Silchar Development Authority had issued a notice to the petitioner that the petitioner, while constructing the boundary wall, had encroached 0.87 meter road in the eastern side of the land of the petitioner. And in addition to that, the permission of the boundary wall, as per the permission of the boundary wall, it was clearly mentioned that in the eastern side, 1.82 meters road existed. However, while carrying out, under such circumstances, the petitioner was asked to show cause why demolition should not be done in respect to the boundary wall, which was in violation. In so far as in so much of the portion of the boundary wall which is in violation. And the petitioner was asked to submit his show cause notice. The petitioner thereupon submitted the show cause notice on 27/5/2024, stating that the construction so carried out was in accordance with the building permit. Thereupon, on 25/6/2024, the chairman, Silchar Development Authority, issued a notice to the petitioner to appear on 29/6/2024 at 3:30 p.m., either in person or through authorized representative for hearing, as well as bring all relevant papers, documents in support of the petitioner's defense. It was also made clear that in the circumstance that the petitioner does not appear, the same shall be heard and decided in absence of the petitioner. The petitioner on 29/6/2024 could not attend the hearing on account of the fact that he had some other important business matters and sought for fixing another date. Thereupon, the petitioner was expecting that some other date would be fixed, but to the shock and surprise of the petitioner, the order dated impugn order dated 22/7/2024 had been passed, whereby the petitioner was asked to demolish, to remove the boundary wall and make the Subir Chandra Saha LP School Road 12 feet wide within 7 days from the date of receipt of the said order. It is under such circumstances that the petitioner has approached this court by challenging the impugn order dated 22/7/2024. Mr. J.L. Borvia, the learned counsel appearing on behalf of the petitioner, submits that the order which had been passed on 22/7/2024 is bereft of any reasons. He submitted that there is not a single mention as to why the objection so filed by the petitioner was not at all taken into consideration. He further submitted there is also no finding that there is a violation committed by the petitioner, and to what extent. He therefore submits that the order to pass is not only suffers from non-application of mind, but also in violation of the principles of natural justice, which is a facet of Article 21 of the Constitution. This court, upon hearing the learned counsel appearing on behalf of the petitioner, is prima facie of the opinion that the order, impugn order dated 22/7/2024, does not mention anything as to which portion of the boundary wall so constructed by the petitioner is causing the violation. There is no mention also in the said order as to why the petitioner's objection was not taken into consideration. In addition to that, as the petitioner admittedly was not heard, and the petitioner was and there was no information given to the petitioner that his application seeking adjournment was rejected. This court finds this to be a prima facie case for grant of an interim order, thereby staying. Accordingly, this court stays the impugned order dated 22/7/2024, which had been signed by the Chairman Silchar Development Authority on 25/7/2024 till the next stage.
King my lord, lordship earlier dictated my lord building permission. That should be my lord wall permission.
Huh?
Construction of wall permission.
Wall,
Has dictated building permission.
building wall.
Construction of wall.
আমি তো জলদি মারি দিব রে, তাহলে বিল্ডিং ভাঙিব।
Lordship.
Procedural item 51.
Yes. You want to withdraw? What liberty? There the problem arises. Why?
That lordship, there were 26 people who have come together from Myanmar due to religious persecution. So others, it was because the criminal case was pending and thereafter the conviction order was there. So now for deportation. So now I want to file WP criminal. Others, 9 members, they also filed WP criminal lordship with a prayer to appear before the UNHCR. So my prayer
The prayer to appear
to get the refugee status, they provided UNHCR.
ENSCR.
But with that regard, I require the liberty lordship.
Ms. D. Ghosh, the learned counsel appearing on behalf of the petitioners submits that the relief which have been sought for in the instant writ petition have already become redundant, and as such, the petitioners would not like to press the instant writ petition. However, the petitioners would like to approach the UNHCR for grant of refugee status. And as such, this court may close the instant writ petition. However, grant the liberty to the petitioners to avail remedies before this court if the petitioner is not granted the asylum status, refugee status. Taking into account the above, this court closes the instant writ petition. However, liberty so sought for approaching this court in the circumstance the petitioners are not given the refugee status is granted.
Item number 10.
Your lordship.
Yes, what is this?
Your lordship, this is an application for winding up of the company, your lordship. What happened, your lordship, here? Since 2004, after filing of this petition, we have no contact with the client at all. And
That-
after listing this case, first of all, I'm sorry, your lordship, last occasion, we could not appear before the court as our name was not reflected in the.
They must have forgotten.
Your lordship.
They must have forgotten this thing.
But it may, your lordship, also,
Is this company still alive? National Plywood Industry.
I have been heard that it has been merged with some other company like, but I do not have any information from my side. But I heard it like, that it is no more there. You know, the amount was also very meager otherwise. Perhaps by this time they have received it or what?
They are in existence. Companies in existence.
On 28/6/2008, also we wrote a letter to the board for industrial and financial recognition. But we have not received any information as yet till date regarding it.
Hmm?
Received any information.
Notice has not been issued.
Your Lordship, and Mr.
Notice has not been served.
Appeared.
Who appeared? Or issue notice returnable by 6 weeks. Notice was sent to the sole respondent, but the AD card has not been received. Perhaps service. Notice may not be declared under here. Lay the matter before a bench. No representation. Leave the matter after 2 weeks. Learned PLG so and so. Passed over for the day. Nothing. Notice has not been issued. If notice have not been issued, then what remains in the instant proceedings?
Your Lordship, this is the plasma office note is there. One office note is
What?
there. That is the Lordship. 21/5/2024.
What flag now? No flag.
One office note is there, Your Lordship. One office note is there.
That I have seen it.
Your Lordship.
How can the court deem notice? How this do? You cannot go with this amount.
I even could not obtain the instruction also, the latest position also last 19 years, no contact with the client. It is from Kolkata. I tried to find out some, but I am not getting it.
When was this file?
2004, Your Lordship.
Chalo. Let me dismiss it on the ground of limitation. 2001, 2002. This is an application under section 433E, read with 434 and 439 of the Companies Act, 1956, seeking winding up of the respondent company. It is seen that a notice was issued, that this court had issued notice on 22/12/2004. However, there is nothing on record which would show that the notice was served upon the petition, upon the respondent. After 18 years, the instant matter has been listed before this court. Ms. K. Yadav, the learned counsel, appearing on behalf of the petitioner, submits that for the last 18 years, the petitioner have not contacted her. This court also takes note of the notice under section 434 of the Companies Act 1956, dated 15/5/2003, which was issued. Dated 15. which was made the basis on which the instant proceedings for winding up was instituted. A perusal of the said notice itself shows that the amount to be payable to the petitioner as on 31/3/2001 was rupees 2,22,707. There is no quarrel with the proposition that the Limitation Act 1963 duly applies. It is further seen that on 3/12/2004, the instant proceedings was filed, which therefore shows that the instant application was barred by limitation. Accordingly, this court finds no ground for further continuation of this instant proceedings, and accordingly the petition stands dismissed. I don't understand why these company matters are coming all of a sudden, all these matters.
Long time it was kept.
Why? Because there were other company judges.
Much of it.
Yes. What is this matter?
My lord, detail, my lord, we have filed this case, my lord, mother of the petitioner or killed by unknown miscreant, my lord. But after getting the affidavit, my lord, submitted by the SC, it came to learn that, my lord, one accused is involved, my lord. My lord, 15/11/2014 is not applicable, my lord.
So you get the under the 357A. That day I passed some order, na, in your favor, na. Let me pass similar order to them, that you can very well approach them.
My lord, in paragraph 5 of the affidavit filed by the respondent number 6, my lord, it is stated, my lord, one accused is involved. It is 3. Paragraph 5, last 4 lines, my lord. One Munnapalli is involved.
Pukradar. Where you have to go? Pukradar? Huh?
Puri, my lord. Case was registered to. Upper PSS 238.
Final report given?
Got any?
Huh? No final report. Yeah, do they say anything? You are applying as per the 1511, which the petitioner claims to be entitled on account of her husband.
Here, my lord, we are children, my lord.
The father, mother was killed.
Yes.
The petitioners, how many petitioners?
First, my lord.
Petitioners herein are
Petitioner number 1 is the married daughter and 2 and 3.
whatever may be. Petitioners are aggrieved on account of the non-payment of compensation in terms of so and so, to which the petitioners claim to be entitled on account of her mother, their mother being killed by miscreants. This court had duly taken note of the documents on record, including the final report is here. No.
My lord.
What
This
is
charge
there?
sheet submitted, my lord.
Huh?
Because the accused is involved, so
Charge sheet submitted. That is called the final report, Mr. Where is that?
there is no any. Only, my lord, stated in the affidavit, my lord, one accused is involved.
Including the it's point number 6.
My lord, 6.
Respond number 6, তাৰপিছত কি লেখাচোন? Wherein, ইয়াৰ পিছত ইয়াত respond number 6 আছে, তাৰপিছত wherein it has been mentioned that
Paragraph 5. But not last 4 lines.
it has been stated that after investigation, it was found that one Munaf Ali, Munnaf Ali, was involved, which led to the death of who was involved in the incident, which led to the death of the mother of the petitioners. তাৰপিছত ধুবুৰী dispose of খালি paragraph 2
Problem.
Problem.
Yes, madam.
The statutory body constituted under the Pharmacy Act of 1948, and the grievance raised here is pertaining to rejection of their proposal for implementation of certain provisions of the Pharmacy Act, which should enable to
There were 3 matters, nahi? Yeah, 1 matter. Okay. Then what happened? Oh, this matter has not yet been disposed of.
if your lordship recollects, lordship had in fact heard the matter, and after that was of the opinion that only the relevant rules which the qualification etc. which provide which the state government would have to provide under section 46 FF of the Pharmacy Act, that needs to be there needs to be a prayer for in fact direction for implementation of that provision, and we have filed an additional affidavit bringing that into record. The impugn order is at page 54.
Aside, direct the state area to accept the proposal of the Assam Pharmacy Council to appoint inspectors under section 26A of the remand. Okay, then what edition and affidavit?
On 17/10/23, we have filed.
17.
17/10/23, we had filed it. As regards non-compliance of section 46(2) FF of the Pharmacy Act.
So there is no qualification and power and duties of the inspectors. There is no rules.
Not yet, rules are yet to be framed.
Now, what is their stand?
Basically, against rejection of a proposal is that there are inspectors appointed under the Drugs and Cosmetics Act 1940, and those inspectors will suffice to implement the relevant provisions of the Pharmacy Act. That is the basic objection which they have brought out in their in the impugn order. And also secondly, that there will be a parallel drug administration running.
So as per them, these qualification, power and duties of the inspectors have been mentioned in section 26A,
Yes, 40 as per
and as such not necessary.
26A, it's not spelled out.
Yes, yes, yes. You say 26A says about the qualification of the inspectors.
Yes, my lord.
Where is it?
My lord, it says, my lord, it says council may with the previous sanction of the state appoint inspectors having the prescribed qualification for the purpose of chapters 3, 4, and 5. Prescribed qualification.
Where?
And my lord, here it is not there, my lord.
That is what she has asked, and you say that this is already done. Who is this person who has done it? They seem to be not serious. Indrani, because she doesn't know head or tail about what is section 46 FF. You categorically mentioned. And she says that the 26A would be there. What is your problem in making the rules? When the Act duly provides.
And they are mixing up the Drugs and Cosmetics Act 1940 and Pharmacy Act 1948. Drugs and Cosmetics Act, that has to do with only the drugs aspect, manufacturing, etc. Whereas the Pharmacy Act is person-centric. It deals with the person, whether he is a registered pharmacist or not, whether he is dispensing.
Yes, that is the reason why, Mr. B. Gogoi, you are fighting a tooth and nail against people who are having duplicate licenses. Pharmacist. What happened there in those cases before the division bench?
We are directed to verify. Thereafter, by issuing notice to them, you guys found to be fake or not eligible. It has been cancelled. About 3,000, I suppose, has been cancelled.
Now, after my judgment, I passed the judgment, na? Then what happened? Isn't that the case of pharmacists? No. No, these are
It
others.
was part of the proceeding.
Those were who were those?
Just passed by M. Bhuya, my lord.
Huh? Oh, yes, yes. Oh, that. That is another one. There I was a lawyer. Okay. Mhm. Pharmacist. No, there is another pharmacist business who did not have the qualifications for dealing with some matter here. What you are
My lord, that was my lord grade 4 employees of Empress.
Grade 4 employees, okay.
Grade 4.
No, this is the only act that is the Pharmacy Act 1948, which has provisions for making inquiry, examining whether in a pharmacy, whether a registered pharmacist is operating or not, whether the dispensing, mixing, etc. of the medicines has been done in the proper manner as has been prescribed there. These aspects can only be gone into when the inspectors as enlisted under section 26A is
So they are
appointed.
not appointing pharmacists under the Pharmacists Act, but inspectors, but they are saying that the person who are there in the drugs and cosmetic act, they are given the additional charge of the pharmacy.
That cannot be. They are saying that the
lord, the
inspectors who have been
inspector-
appointed under the Drugs and Cosmetics Acts, they can themselves, they can settle that issue, examine these persons. Whereas the Drugs and Cosmetics Act 940 provides the functions which the inspectors appointed under the Act has. And they are not empowered to examine whether the pharmacy has been operated by a registered pharmacist or not, whether they are
Now,
dispensing-
as to whether they are not or not, but can't the government empower them by virtue of this act?
No. They have to, because that is the Drugs and Cosmetics Act is altogether a different act and it has a different object altogether. And the powers, the functions of the inspectors appointed under the Drugs and Cosmetics are spelled out there. And the powers and functions of the pharmacists appointed under the Pharmacists Act 1948 has been spelled out here. And the
So
pharmacist,
can't there be additional charge?
there much of the Drugs and Cosmetics Act came in the year 1940. And of the legislature, obviously considering that there was another legislation necessary for regulating the business of pharmacy, had brought in the Pharmacy Act of 1948, which defined powers, the inspectors who are going to be appointed under the Pharmacy Act 1948, what they are supposed to, what functions they are supposed to carry out, specifically with regard to the persons who are operating the pharmacy. Whereas the sole object of the Drugs and Cosmetics Act, they are centered around the drugs, manufacturing, etc. of the drugs. Whether the proper right, that is the inspect some and substance of the drug and substance, these cosmetics at 940.
What about a judge who is being given a certain powers of a civil powers, but who have been additionally given certain criminal powers also?
If the
Now
the
you
act-
see a lot of transfers and all these things. A judge is being specifically empowered. Just for example, he's specifically empowered to be a special judge under the Prevention of Corruption. So, inspector of Drugs and Cosmetics Act, can't he be given additional powers in terms with the Pharmacy Act?
additional powers, if obviously the act will require amendment.
They are being given additional
And my lord, the
powers.
functions
Because
that
the
are
act
vested
itself
under
is-
the pharmacy practice regulations, my lord, that my learned friend is referring to. That clause 5 of the regulation says that the owner registered pharmacy shall allow and cooperate with the inspector appointed under the Drugs and Cosmetics Act also, my lord, because the functions and roles.
Now, that they will have to do.
Yes, my lord.
That is another thing.
Yes, my lord.
Because why they have to do is, if a pharmacist says that, no, I'm not going to give these medicines to you.
Yes.
Because you have no control over me. Therefore, it is this regulation says.
And my lord, that clause
But my
5,
question is, can a inspector of drugs and cosmetics act not be given the additional power under the
yes, my lord,
pharmacy?
that is given. I am referring to that clause 5, clause English 5, Roman 5 says, my lord, any
What?
inspector
English
may,
five, Roman five?
my lord, regulation 5,
Where?
page 32, my lord. So any inspector may, if the pharmacy act, my lord,
Where? 32? Where?
page 32,
Of?
pharmacy practice regulations 2015.
Where will I get it?
My lord, in this act, it is here, my lord.
Pharmacy Act.
Yes, my lord, pharmacy act. The pharmacy practice regulations 2015,
Okay.
2015, regulation 5, my lord.
Yes.
The pharmacy inspector to inspect pharmacies, my lord. So, my lord, there Roman 5 says, exercise such other powers as may be necessary for carrying out the purposes of chapters 3, 4, and 5 of the Pharmacy Act or any rules made thereunder.
So that is the power given to
the inspector appointed under the
owners
Drugs
shall
and
allow
Cosmetics Act.
the cooperate with the inspectors appointed under
the
drugs and
Cosmetics
so
Act.
and so by the State Pharmacy Council to
This has to be read with
inspect
clause A.
premises where drugs are compounded. Any inspector means
May.
both, either of it,
Yes, my lord.
may inspect any premises where drugs or AI is dispensed, so and so, institute prosecution under the executive committee of the AI, exercise powers under as may be necessary for carrying out the Pharmacy Act. So you mean to say any inspector when it is being meant, it means an inspector of the Drugs and Cosmetics Act.
Appointed under the Drugs and Cosmetics Act.
Not
He
sure
is
where you
empowered
get
to take, my lord, carrying out the purposes under the Pharmacy Act also, my lord.
Please, clause B cannot be read in isolation. This has to be read with clause A. Because clause A clear, regulation 5, clause A says, owner oblique registered pharmacist shall allow and cooperate with the inspectors appointed under the Drugs and Cosmetics Act 1940 and section 26A of the Pharmacy Act 1948 by the State Pharmacy Council to inspect premises where drugs are compounded or dispensed. Then thereafter, any inspector that comes. So this has
The
to be read with
inspector
clause A.
appointed under both, my lord, Drugs and Cosmetics Act also.
And moreover, when there are two separate. acts,
Now,
it
when
can't be
you
the powers.
appoint a inspector
Yes, my lord.
under the Drugs and Cosmetics Act, do you also give the power for pharmacy?
Yes, my lord.
Where?
My lord, the Pharmacy Practice Regulation 2015 provides the power to the inspector appointed under the Drugs and Cosmetics Act, my lord, also. The Regulation 5. It provides powers to the inspector under the Drugs and Cosmetics Act as well as the Pharmacy Act, my lord.
So as per you, there is no necessity for special and for in view of the regulation.
To carry out the prospective of this regulation 2015, my lord. As contended by the petitioner, my lord.
Madam, what is happening in other states?
Most of the states, they have implemented, in fact, in my neighboring state of Mizoram, they have also implemented this provision section, 26A. We have enclosed the document there at page 659.
Madam, we do one thing. We take up this matter for final disposal on a day, Tuesday.
Next Tuesday.
I think it takes some time. How about 10th of September?
Okay. Can it be on 12th of September?
Ms. D. Buragoin. Counsel appearing on behalf of the
Health and Family Welfare Department.
Health and Family Welfare. Hearing the learned counsels for the parties, this court is of the opinion that this matter may require a further hearing. However, the counsel appearing on behalf of the petitioner expresses urgency, taking into account that the respondent state have not adhered to the provisions of Section 26A of the Pharmacy Act of 1940. And thereby effective measures which are required to be taken under the Act of 1948 have not been taken. That view of the matter, this court fixes up the matter on 12th of September 2015. Each state an attempt shall be made to dispose of the litigation.
Right.
I pray for an accommodation in the matter just for the day works. We had circulated a mention slip yesterday itself, Lords.
Yes, what is this matter about?
Was the matter pertains to a settlement of a fishery Lords.
Then,
We have challenged the settlement of the respondent number 6 Lords.
point number 6 is running.
She is
Oh, run. We'll have it sometime in the month of January 2025. Taking into account that on the earlier occasions, an adjournment has been sought for by the counsel appearing on behalf of the petitioner. No interim order? There is also no interim orders. Taking into account the above, list these matters on 11th of November 2024.
Bit earlier, Lords. For the applications.
I am in item number 14.
8th of November 2024.
Before the
Lordship, they are seeking agenda
6th of November 2000. Hello. 2nd of December 2020. 2nd of December.
It will be November.
Kundu disila agote? 6th of November. Yes, what is this?
Instruction.
Withdraw. Yes,
FN Jaman.
appearing on behalf of the petitioner submits that she has instructions to withdraw the instant petition. Taking into account the above, the instant petition therefore stands closed on withdrawal. Interim order, if any, stands.
Not that may can be fixed and
Yes. What do you have to say? item number 52. Just 1 minute, 18 I'm taking.
PTC lordship.
Yes, what are you challenging, madam?
Order passed by Secretary. Order passed by Secretary BTC, Lord.
Yes, what is it?
Is our names are already recorded in the revenue record. They filed a miscase before ASO, Lordship. After receiving notice of approach ASO, we have filed one miscase before settlement officer, Lordship. Settlement officer passed an order stating that our deed and their deed all are false documents. And so ASO can pass any order directed to retain our name, Your Worship.
Where?
There,
The order of 25-5.
Lordship.
Lordship is taking up the matter.
Yes. Where is that order of 25-5? Yeah.
Annexure 3, page 27, settlement officer's order. Lord. Even portion page 30, Lordship.
What power is being exercised by the Secretary Land Revenue Development?
PC has filed an affidavit in opposition. That says that Lordship, the power of Deputy Commissioner is situated with BTC. As per.
Respond number 4.
Yes, Lordship, it is. Respondent number 3, 4, and 6. Page 47 of that affidavit in opposition, there is a notification, Lordship.
Under what provision?
I read, Lordship, whereas as per clause 5.7 of the MOS 2003 and Government of Assam Office Memorandum number so dated 2004, the offices of the Deputy Commissioner and Superintendent of Police are kept outside the superintendence and control of BTC, and as land and land revenue is a.
So you're paying for a BTC?
R.K. Musali was a paid. Therefore, the council head of the department directorate formed by the BTC with regard to land and land revenue department by notification number so and so dated so and so respectively shall be competent to deal with all land and revenue matters of 4 districts, and the powers of the deputy commissioner as provided under the Assam Land and Revenue Regulation 1886 shall be vested on the Director of Land Record Surveys and Inspector General of Registration of BTC and the appellate authority.
You're reading which paragraph?
Page 47, Lordship, that is the notification of the affidavit in opposition, Lordship, filed by 346.
So against an order passed by the deputy commissioner,
Our order, the order which was passed by settlement officer was in favor of us, Lordship. They ought to have challenged that order before Revenue, Board of Revenue. Even if we assume that Secretary BTC is equated with Deputy Commissioner. Order passed by settlement officer, well, with the order passed by Deputy Commissioner. Lordship. Secretary BTC, Lordship, can be allowed to, Lordship, occupy the appellate authority, Lordship. As per this notification, Lordship, Deputy Commissioner is equated with Secretary BTC. And
so you mean to say the Assam Board of Assam Land and Revenue Regulation does not apply to BTC?
Power is vested upon BTC.
It doesn't apply to BTC.
All the 34 powers have been vested with BTC. Among those 34 powers, land matters are also within.
Understood. There's no quarrel with that. I'm only asking as to whether the Assam Land and Revenue Regulation applies to the BTC.
yes, Lordship. But
My lord, so far 3 subjects are like with the state government. Law and order situation and this land matters.
I'm not on that. Whether this subject or not, I'm not on that.
But thing is,
Whether
my
the
lord,
Assam Land and Revenue Regulation excludes the BTC area.
I think no.
Therefore, under such circumstances, when a law is there that a challenge to be made in respect of a particular order, I may understand by the secretary or the deputy secretary, the deputy commissioner. On that behalf, it will be the director of land records. It's okay. They can very well. But can by way of a notification, they take away the powers or amend 147 of the Assam Land and Revenue Regulation?
Until
as
until
per
it is
147,
challenged,
Lordship,
until unless somebody challenges it, it is set aside. I think that should prevail the whole the field. But thing is, yes, by Leonard is intelligently taking to other direction. Okay. Thing is not that. Kindly Lordship see page 14 of our affidavit. My learned friend is very intelligently taking the matter to totally to different direction.
Hmm.
Kindly see now our affidavit, which is filed on 3/1/24. Page 14, annexure 1.
Where is it? Affidavit filed by respond number 4. 7, we don't have affidavit.
Filed on 3/1/24.
Who filed maybe in some other application.
the interlocutory application
Huh?
for vacating the stay order. That is not additional affidavit or affidavit in opposition.
Sorry,
Oh,
sorry, my lord,
okay,
sorry,
that-
I'm sorry.
there's one
It is IA number 164.
Ah.
IA number 164.
Yeah. You are there in with him?
I am for response number 8 to 8D, my lord.
Who are you?
Brother of the my lord.
Fantastic. He's your brother, na? Get hold of a BTC council. For that,
Yes. Now, Lordship, kindly see page 14
yes. Of your,
of my IA.
Hmm.
164/24. Here, Lordship, Shah Alam Talukdar, I am Shah Alam Talukdar. And Shah Jamal Talukdar is perhaps he is represented by my landed friend. So I am for Shah Alam Talukdar, who is respondent number 7 in this writ petition. Now, one Mufizur Rahman Talukdar,
Hmm.
he has donated this 7 biga 4 katha 12 lessa of land to these 2 brothers when they were minors. And after that, my lord, this this is the register cell list that may be seen page 15, man.
Page
15, 1-5 of my IA.
Yeah.
Shahalam Talukdar and Mohammad Shah Jamal Talukdar. Likhitong Mufizur Rahman Talukdar. This Mufizur Rahman Talukdar donated these two brothers when they were minor, 7 biga, 4 katha, 12 acres of land. Thereafter, my lord, this land was duly demarcated in their name. Kindly see page 19.
Then
Page 19 and vernacular portion is page 20. This donated plot of land was mutated in the name of two brothers. Page 19 and 20. Then Lordship would kindly come to page. Then what happened, my lord? In the meanwhile, they discovered that other persons have been also included their names in the Namjari. In the Namjari, that is mutation, this petitioner, these petitioners, they included their names. That Lordship may kindly see page 34, man.
yes, then
Page 34, kindly see. Page 34. Here, originally our name is there. Shah Alam Talukdar, Shah Jamal Talukdar are there. But then, my lord, Khairat Jamal Talukdar, who is the petitioner, Bodiur Jamal Talukdar, Surat Jamal Talukdar, they came into sin. These three persons included their names in the mutation register. Then when we came to know about this, we immediately filed a petition before the ASO, Bogriwari, that these three persons have fraudulently included their names in the mutation register. Then, my lord, the ASO Bogriwari issued a notice to all of them. Kindly see now page 22. Page 22. First party Shah Alam Talukdar, Shah Jamal Talukdar. Then Surat Jamal Talukdar, Bodiur Jamal Talukdar, these are the writ petitioners. He issued notice that such and such complaint has come that you have forwardly.
no, understand. Those are things are not necessary, Mr.
No, these are necessary, my lord. They have
No, not necessary.
they have included their names fraudulently.
Very
The
13
ASO started
You
inquiry.
see, the entire case, I've seen the order now. The order categorically says that the deed
No,
1326.
what is the locus? Only that is my lord.
Mr. Mahmood, kindly understand. The basis on which the order was passed is that their deed number 1326 executed on 27/3/2014 is a forged document, and as such their name have been struck off. That's the basis.
No,
I understand.
that was intended to be done. Then they did not face the ASO. They filed a petition before the ASO. When the matter was pending before the ASO, he did not pass any order, only issued notice. They were afraid that our fraudulent activity would be discovered. Then they filed a petition, rightly or wrongly, by saying this and that. And ASO passed the order that both the deeds are not. But this sub-registrar has submitted a report that deed of this Shah Jamal Talukdar, Shah Alam Talukdar are genuine. But deed of Khairat Jamal Talukdar, etc., who are the report, that is totally false.
That is what I've looked into. That is that page.
So that is the report of
That
the.
is the page 37 of your IA. Isn't it?
Yes.
Yes. I've looked at Mr. Mahmood. See, it doesn't take so much of time. I want to ask him one thing. You take your seat. I've understood. Yes, Mr. Musairi. Tell me, what is this type of, does the Assam Land and Revenue Regulation is applicable to the, what you call, BTC area?
Yes.
Huh?
Yes.
So under such circumstances, an order which is being passed by the secretary, is the secretary given the same powers of that of the Board of Revenue?
As per notification,
Because you see, the director of land records have been given the power, which is similar to the power of the deputy commissioner. Okay, very well. Because the deputy commissioner is outside the jurisdiction of the BTC. So the power has been given to the director of land records.
I think only the power of deputy commissioner is given. Not,
What about the other one, that was secretary?
secretary, my lord.
How,
Only
whose
power
power is given to the secretary? Means, are you taking away
Same
you
power
think-
of deputy commissioner.
Huh?
Same power of deputy commissioner.
of the secretary to me?
My affidavit in Excel sheet.
So that is what I am saying. This affidavit of the fourth district, the power of the deputy commissioner as provided under the Assam Land and Revenue Regulation 1886 shall be vested on the director of land records and inspector of so and so, and inspection of BTC. And the appellate authority in this context shall be the departmental secretary of BTC. Meaning thereby, is the power of the deputy commissioner of the board of revenue being taken away?
Only power of deputy commissioner, not board of revenue.
No, here the power of the deputy commissioner as provided under the Assam Land Records shall be vested in the director of land records and survey of BTC. And the appellate authority in this context, appellate authority over this director shall be the departmental secretary. So are you therefore amending by way of this notification the Assam Land and Revenue Regulation? That is my specific question. Yes, you can very well take in that the BTC is out. For BTC, deputy commissioner is not there, so we can have any other official like the director. It's okay. But can you take away the powers of the board of revenue, because an appeal from the deputy commissioner lies to the board of revenue? So are you amending the Assam Land and Revenue Regulations, which duly applies to the board BTC by way of this notification? That is my question.
I am not clear, my lord. Let me.
You are not clear?
May I submit, my lord? I have some information.
Yes.
First, my lord, first thing is this, first power goes to assistant settlement officer. If any order is passed by ASO, then appeal would lie before the settlement officer or the deputy commissioner. Or any circle officer order is passed, then appeal will lie before the deputy commissioner. Then that is 147A. 147B, then it will go to, if the order is passed by settlement officer, then DC does not come here. Because power of settlement officer, the deputy commissioner, so far land matter are equal. So here, the settlement officer has passed an order, rightly or wrongly. So secretary BTC has is the appellate power.
That is my question to him. By way of a notification, can you take away the jurisdiction of the Board of Revenue? My specific question to him is that. You see, an appeal from a deputy commissioner or to the settlement officer or from the settlement lies to the Board of Revenue. So by way of a notification, can you take away that?
But at the same time, until the notification is set aside, the
Understood, but if a notification on the face of it is completely contrary to the provisions of law where some land and revenue regulation applied, there's no quarrel. A part of that notification is okay. As regards director of land records being given that power instead of the deputy commissioner is absolutely right. But how do you take care of an order passed by the settlement officer being decided by the secretary?
there is only that notification.
No, can by way of a so this would amount to no, therefore this would be amending an act by way of a notification.
Yeah, that's through subordinate legislation, that is not permissible. But here, my lord, that question may be kept aside. Here, what are their locus? Because I have.
No,
sold
the
my land.
locus is that then the mutation has been cancelled. The
This
locus is
an
there.
indication for, the sub-register says your deed is false.
Understood. Sub-register may say whatever you need, but who is to decide?
Up to that extent, after that, this is finality because they have not filed appeal against that order.
Where?
that they have, the sub-register has said that deed we have verified with this Khairab Zaman Tarukdar, Sohan Tarukdar, we have verified, nothing is there, that is false. So against that, they have filed no civil case anywhere, saying declaration
That
of
is, that is a different aspect,
Yeah,
Mr.
I understand that,
That
but
is a
my,
different thing.
this
But
matter-
only, I understand your problem. Your understanding, there is a stay to that order.
Yes,
So that is what, I'll take care of that.
yes.
You get the point?
Right,
You,
I
what you have done is absolutely wrong. How can you do this? You are amending the provision of section 147B.
instruction, my lord, regarding this notification.
We'll have it on next week.
Next week.
Get your instruction or withdraw this to that extent. Only that portion from the secretary. Because what will otherwise happen is there will be a big issue out there. You are amending a provision of the regulation. How can you do that? Because if you don't have the power in this thing, then the order of the settlement officer which is there has to be challenged somewhere. He has rightly challenged it before the secretary.
Yes, my lord.
He has rightly challenged because of these notifications. But whether the secretary can exercise at all the power. The instant petition has been filed by the petitioner challenging the order dated
25/5/2023, page 32.
25/5/2023 passed by the Secretary, Land Revenue and Disaster Management Department, Borolan Territorial Council, Kokrajhar, whereby the mutation made in the favor of the petitioners were cancelled on the ground that the deed on the basis of which the petitioners have sought for cancellation, on deed on the basis of which the petitioner's name were inserted was a forged document. The said order has been put to challenge on various grounds, including the ground that the Secretary BTC, Secretary Land Revenue and Disaster Management Department, Borolan Territorial Council does not have the jurisdiction to pass the order dated 25/5/2023. Pursuant to the filing of the instant writ petition, the respondent number 3, 4, and 6 filed an affidavit in opposition, wherein various details have been given. However, it is very relevant to take note of the notification dated 30/12/2016 by which power has been conferred upon the Director of Land Records, Survey and Inspector General of Registration of BTC, as well as to the Departmental Secretary of the BTC. From a perusal of the said notification dated 30/12/2016, it is seen that the powers of the Deputy Commissioner, that taking into account that the office of the Deputy Commissioner and the Superintendent of Police are kept outside the superintendence and control of the BTC, as well as the land and revenue is transferred subject to the BTC. The powers of the Deputy Commissioner as provided under the Assam Land and Revenue Regulation 1886 was vested upon the Director of Land Records, Survey and Inspector General of Registration of BTC. This court, however, finds no fault in that aspect of the matter. However, interestingly, the appellate jurisdiction has been conferred upon the Departmental Secretary of the BTC. And in the instant case, the the Secretary, Borolan Territorial Council, in exercise of its appellate powers, passed the impugned order dated 25/5/2023. A question therefore arises as to whether by way of this notification, the provisions of section 147B of the Assam Land and Revenue Regulation 1886, which stipulates that an order passed by the Deputy Commissioner or the settlement officer lies to the Board of Revenue, Assam Board of Revenue, have been amended Pusto. Mr. R.K. Musairi, the learned counsel for the BTC, submits that he will obtain necessary instructions within a week's time. Pusto. List the matter again on 19th of August 2024 at 2 p.m. Pusto. What is this IA for?
A vacation of the stay order, my lord. I 164. Because that was obtained in a very colorful manner. Lordship has already read about the report of the sub-register that is fact document. Now, what is their locus? They have no locus.
What no locus? Their mutation has been cancelled.
Cancel, that is why, my lord.
That is what the locus is. Why you are confusing your locus with he has no case. A cause of action and no locus is a different aspect. Don't you think so?
Some relief, my lord, because I am a cancer patient, my lord, and I have to sell the land, but due to stay order, I cannot sell. So
There's a stay not to sell.
stay of the order of the Secretary BTC.
That does not prohibit from selling.
Then lordship may kindly observe, because they are saying that it is a High Court's order, you cannot interfere unless the High Court interferes. High Court.
Let me dispose of that IA then. Continuing the interim order, but making it clear that it should not affect your right. Because you are your name.
I have been
No, no.
given the land.
What has happened is some land has been brought out there. Has he taken over the entire land? How much?
We have 5 brothers, lordship.
How much land is in your land as per the sale deed?
3 share, lordship.
Sale deed is also.
We are
annexed.
occupying 3 share and he is occupying 1 share and the.
No, I want only 1 share, my share. Shalom Talukdar share I want. I don't want more.
Your share is how much?
My share is 7.
Out of 5, only 1 share, lordship.
No, they are not the.
How much is your share?
My share is out of 7 biga. 7 biga, 4 katha, 12 resa, 50%.
They have already filed a title suit that was dismissed, lordship, in regard to this, and they're all disputed questions, lordship. I have 1 sale deed, he has 1 sale deed, lordship. So civil.
No,
is the
we'll
completed
do one thing
process,
on
lordship,
next date. We'll take it. Don't worry.
of this, lordship. Interim to be continued, lordship.
When I fix it at 2 o'clock, don't worry, I'll do it.
Interim till today, lordship. So it can maybe continued, lordship.
Same order passed earlier shall continue till the next date.
I'm deeply obliged.
And attempt maybe to dispose of the matter on that way.
2 o'clock, I fixed.
18.
Yes, what is this, Mr. Mahmood?
I am the writ petitioner.
Hmm.
My grievance is that, my lord, government sanctioned some construction of road and other plantation, etc. Kindly see page 34 of the writ petition.
Then?
Page 34. It was block Matia, Panchayat, Navagata, Shimlitola, work start financial year 21-22, ongoing work code number so work, development of fishery tank with plantation near Shingramari, 1 number Masjid.
But what is happening? Why have you approached me?
Work has been started 1.5 kilometer away, covering my patta land.
Patalena, you are adversely positioned.
No. There
Your
are,
case is of adversely possession.
no, I am submitting, my lord. There are 4 bigger 2 kata 10 lessa patta land. And 3 bigger 2 kata 10 lessa khas land.
So your land of 4 biga 2 katha 10 lessa has been taken. It's a patta land.
Yes, it is a patta land.
There they are constructing a fishery.
My lord, our fishery is being constructed on the government land. The Jamabandi is at page 26. If my lord comes to my affidavit at page 78.
Page
78, my affidavit in opposition filed by the BDO.
78. Yes, tell me.
My lord, the petitioner, number 1, Nazir Islam, had himself filed an application form for constructing a fishery pond under the Manrega scheme. Nazir
Page 78.
78 of my affidavit, my lord.
Yes, where is it?
Page 78, Nazir Islam, the petitioner, whose
First proposal, second proposal.
so his proposal was for construction of a fishery pond and in on dark number 326.
Page 77. You must be referring to some other page. Wait.
58,
Yes, yes.
Annexure
This
6.
is an application.
Application, my lord. This application was signed by the petitioner number 1, Nazir Islam, stating that dark number 326, on that particular dark number, this fishery pond should be constructed, my lord. Thereafter, he raised this dispute that this dark number belongs to me,
To whom?
belongs to the petition. So accordingly, he files a complaint to the DC. The DC forwards the complaint to the circle officer at page 110, my lord.
Page?
110, my affidavit.
Yes.
He writes,
Then?
after that, the circle officer is directed to file a status report. He files a status report, which is annexed at page 111, stating that dark number 326 is totally government land, my lord, which the petitioner has adversely possessed.
Like to state that 1 biga 2 katha out of government land, measuring 8 bigas so and so covered by the Iman and of government land. Land measuring 70 biga covered by so and so been identified by the LR staff and the state land schedule has been shown in the official of man in. Then?
So his case is, my lord, that dark 326 belongs to me, whereas as per the records, complete 326 8 biga land belongs to the government. In fact, he has filed his Jamabandi at page 26 as well.
Okay. Now, Mr. Mahmood, where is your patta?
My lord, page 19. What my landed friend said, they are not doing anything over my patta land. The lordship may kindly observe this and pass the stay order. We have the objection.
326, page 19.
Yes, page 19.
It is
First,
patta number 206.
206 and land measuring, my lord, 3 katha. Then lordship may kindly see page 21.
Yes.
Here, patta number 182 and area of land, my lord, 1 bigha, 0 katha 11 lessa, 1 bigha 0 katha 16 lessa, 1 bigha 1 katha 0 lessa. Then lordship may kindly see.
So you have no business with 326.
No business with 326. That's government land.
And they are only constructing in
326 and dark 2.
Huh?
And dark 2. Dark number 2. Yes.
So they are constructing in, so your construction should be limited only in dark number 326 and dark number 2.
Dark number
Don't disturb the petitioner's patta land. Matter over.
That's all. That's it, number.
What is there?
That's it.
Because in the adverse position.
No adverse position.
How
There's
can
no
they become
government.
adverse
There
at-
is no
government
adverse position against the government. Law is very clear.
In fact, my lord, page 26.
Well, that kind of very strict order may be given, otherwise they will take the benefit.
Okay.
That mean patta land, they should not interfere at any cost.
Third, Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner. Mr. P. Bordlow appears on behalf of the PNRD department. And Mr. Taluga appears on behalf of the administration. Walpara. The petitioner herein petitioners herein claims that they are owners of various plots of land measuring 2 bigha covered by dag number 339 of patta number 201 semicolon 1 bigha 2 katha 10 lecha covered by dag number 19 of patta number 182 semicolon 1 bigha of dag number 21 of patta number 68 totaling to 4 bigha 2 katha 10 lecha situated at village revenue village Garopora Tari Moza Motia Revenue Circle Makia in the district of Walpara, Assam. It is the case of the petitioner that the petitioner also has another plot of land, is also in possession of another plot of land measuring 3 bighas 2 katha 10 lechas, covered by dag number 326 Exona of Revenue Village Garopara Tari Moza Matia Revenue Circle Matia in the district of Gwalpara, Assam. It is the further case of the petitioner that the respondent authorities are going ahead with the construction of a fishery tank oblique pond and thereby violating and thereby trying to take over the possession of illegally trying to take over the possession of 4 bigha 2 katha 10 lechas of the patta land of the petitioner, as well as 3 bigha 2 katha 10 lechas, which is a government land which the petitioner adversely have been possessing. Mr. P. Board, the counsel appearing on behalf of the respondent PNRD department submitted that one Nazir Islam, who is that? Where is that
Petition
document?
number 1, my lord, page 78.
Page
78. On my affidavit in office.
very difficult. You people don't prepare your papers properly, na? Because that here the pagination is different from here. Here it is 86. Admitted that one Nazir Islam, who is the petitioner number 1, had submitted an application for a fishery with plantation work in his land measuring 10 bighas covered by dag number 326. Upon such an application being received, the same was forwarded to the Deputy Commissioner. Where? Forwarded to the Deputy Commissioner. And it was was forwarded by the block development officer to the circle officer Motia Revenue Circle to make an inquiry as regards the land so offered by the petitioner number 1. It was mentioned that the land in dag number 326 is a government land. It was also mentioned by the said communication by the circle officer that land measuring 17 bigha 1 katha 9 lecha covered by dag number 2 have been identified by the concerned LR staff, and the said land have been shown to the officials of the block development officer Motia in connection with construction of the MGNEREGA scheme, namely development of fishery tank with plantation near Singimari 1 number Mojit.
Along with dag number 326. 1
I will say it. Mr. P. Bodlow, appearing on behalf of the P&ID department, submits that the respondents are not going to construct any fishery or tank in the Patta land of the petitioners. The construction of the fishery oblique tank would only be carried out in Dag number 326 as well as Dag number 2. As mentioned in the communication dated 16/2/2023 issued by the Circle Officer Motia Revenue Circle. I've heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. First, this court is of the opinion that the land belonging to the petitioners at measuring 4 biga 2 katha 10 lechas in various dags and patta numbers as referred to herein above cannot be used by the respondent authorities for the purpose of construction of the fishery oblique tank without acquiring the same in accordance with the provisions of law. However, the respondent authorities would always be at liberty to carry out the construction of the fishery and tank at Dag number 326 as well as in Dag number 2, which, as per the certification of the circle officer, is a government land. It is also seen that it is an admitted case of the petitioner also that the said Dag number 326 is a government land. Under such circumstances, this court therefore disposes of the incident with petition, thereby directing the respondent authorities not to construct the fishery oblique tank in the Patta land of the petitioner, the details of which have been referred to in the previous segments of the incident order. However, the respondent authorities can very well go ahead with the fishery and tank construction in Dag number 326 as well as Dag number 2.
But without acquiring, side by side, lots of can without acquiring and paying compensation. That is implied. I understand that.
Without acquiring in accordance with law, I said that, na?
All right.
Yes, what is this?
Has filed an additional affidavit just today. I have been served with a copy of the same. So this matter
Submitted by learned counsel for the bank was appointed by the RBI suddenly expired on month of appointment of a new. Yes, what is this?
the respondent bank had conducted an auction of a particular property. I came out as a successful bidder. I paid the entire amount of rupees 55 lakhs. After that, the property was not handed over to me.
Document of sale?
Only sale certificate is there. Sale deed has not been executed. And subsequently, the petitioners filed a money suit in the year 2017. This auction took place in 2014, Lordship. In 2015, the sale certificate was issued. In 2016, the bank had written a letter to the deputy commissioner to assist in getting the possession of the property. But they could not do that. Ultimately, in 2017, after all the other attempts, the petitioner filed a money suit. Now, subsequently, I got to know about a judgment passed by this honorable court, wherein a similarly situated case, auction took place, but possession was not handed over. And this honorable court had directed that the entire amount should be returned along with interest.
Did I?
Lordship,
Which court?
this honorable court in another similarly situated case.
Hmm?
On the basis of that judgment, the money suit was withdrawn with liberty to file appropriate petition before this honorable court. As such, I have filed the instant writ petition with a prayer for a refund of with a prayer to refund the amount along with interest. Now, my lord, the respondent authorities filed an affidavit in opposition stating that we are ready to execute a sale deed. But in the meantime, the reason why they could not hand over the property to us in 2016 that they have stated was because an injunction order was passed by the learned trial court in a dispute between a third party and the mortgager. There was an injunction in that particular title suit. So due to that, the property was not handed over to me.
Now they are going to give it to you.
If I may complete. Now they agreed in the affidavit in opposition. After I withdrew the money suit from the learned trial court, the title suit between the mortgager and third party got dismissed for default. In spite of there being an injunction in the title suit, the bank did not take any step before the learned trial court, did not intervene, nothing was done by the bank. Immediately after the filing of the affidavit in opposition by the bank before this honorable court, the title suit has been restored. The title suit has been restored, and now again the injunction is still in operation, Lordship, since the title suit has been restored. I pray that the bank should not only pay me the principal amount along with interest, but they should also pay compensation, Lordship. Reason being, Lordship, I had purchased that particular plot of land for construction of my residential premises. There is a Supreme Court judgment, Lordship. I had placed on the last date. I don't know whether it is there on record or not.
Pioneer Urban.
Yes, Lordship. Pioneer Urban. This is a real estate matter, but the principle of this case will apply to the case, to my case as well. If I may take your Lordship to paragraph 30 at page 476.
But in this case, whether RERA will apply?
Lordship, RERA as such will not apply, but since I had purchased for residential purpose and I am being deprived of the same, the
Don't
rate
you
which
think
was-
that is a subject matter of a suit? You are purchasing suit for damages? That whether you are purchased for residential purpose or not, how will I know?
Lordship, there is a standing structure on that particular property.
What?
Standing structure is there on the property. In fact, the bank itself has written letters to clear the livestock, etc. The bank's letters are there.
Clear? What is there to clear?
For clearance of livestock, etc., the bank itself has written a letter to the deputy commissioner as well as to the officer in charge of Buddhist police station. And that has been brought on record by way of the additional affidavit which is being filed today. Or has been filed probably by now.
Now, what do you want? Your petition, where is your petition? Let me see.
Initially, when I had filed the writ petition, my prayer was to the extent of refund of the principal amount along with interest.
And
Lordship,
now
that
you
was my
want
initial
to
prayer.
enhance your prayer.
Lordship, that is due to the subsequent development by the respondents. The respondents stated on oath before this honorable court that they are ready to execute the sale deed and hand over the property to me.
In view of the vacation of the stay order.
Yes, Lordship.
Now they cannot.
Yes, Lordship. So this was on oath.
Yes, madam, what are you going to do?
My lord, I just pray that the additional affidavit may be brought on record and the matter may be heard tomorrow or day after
Did
for final decision.
all prayers she made. And
The humble prayer is.
madam, why don't you settle it out? What is this?
Madam,
Why
we are
don't you
willing
make the
to
payment along with interest? You are to return it.
We
You have
the
no,
possession,
you are
physical
not in a
possession.
position to hand over the possession to her. You have the pendency of that suit. Then what is to there?
But
The
my
more,
lord,
the
the
more and more it is going to happen,
Then-
madam is going to get more and more clever with various judgments. With this judgment now, she is now limiting herself to the 55 lakhs plus interest plus the compensation as regards her loss of residence. But later on, may also become more clever, coming out as regards she would have rented it out and how much she would have earned. Settle it out.
In 10 years.
Huh?
10 years.
At that, when the court dismissed this for default, we were willing to execute the sale deed immediately and hand over the possession. And we also have the certificate of possession, which was executed in presence of the executive magistrate. Thereafter, my lord, after handing over the possession, encroachment took place. Encroachment through livestock, that is. Livestock, that is, a few cows were kept in the land, and those, to remove those cows, they approached us, and then we had our security guards kept there, who clearly gave a status report that no person is encroaching, only the livestock are there.
Lordship, if I may clarify on this aspect, when the affidavit in opposition was filed, this was nowhere the plea that we approached the bank after.
You did not have a plea out here that you are going to ask for additional compensation.
Lordship,
Then-
but the statement.
Then why you say pointing out you have mistake? Okay, Ms. So-and-so appearing on behalf of the respondent, bank submits that an additional affidavit has been filed. However, the same is not on record. List the matter again on 13th of September, bringing on record the same. Yes?
My lord, the petitioner is a senior citizen. There is some urgency in this matter. 55 lakhs have been stuck for the past 10 years.
Are you not paying that?
My lord, this.
In the meantime, you
there was
paid
a-
that,
There was a
55.
party also was going on, my lord.
We'll consider about the interest.
That
Pay the
was withdrawn in, and the bank was also.
Pay the
bargained.
55 lakhs, we'll consider about the interest. Pay the 55 lakhs. You have to pay. You have sold the property which is unsaleable. Then you have put her into more trouble.
Your lordship may record that, my lord.
So pay that, because you see, why I'm saying it, once you pay it, the interest ceases. We'll consider about the interest. I'm giving it till there. Make the payment of 55. There's no quarrel with that.
In fact,
You are not are you in a position to hand over? Tell me, are you in a position to execute the deed of sale?
With regards to the existence of the injunction order, no, my lord.
we had approached them before
No.
the title suit was restored.
Miss
Dr. P. Agarwal, lordship.
Dr. P. Agarwal, the learned counsel appearing on behalf of the petitioner, and Miss and so appearing on behalf of the respondent. The instant case has been filed by the petitioner, seeking refund of the amount of rupees 55 lakhs along with interest from the respondent bank, taking into account that in spite of the petitioner, after participating in an auction sale and having paid an amount of 55 lakhs in the year 2014, the bank authorities have not been able to provide. The bank authorities have not only executed the deed of sale, but also had not handed over the possession. It is also seen from that during the pendency of the instant writ petition, it is also seen from the records that the reason why the bank would not execute the deed of sale or hand over the possession is in view of a suit pending between the debtor and the creditor,
Mortgager.
between the mortgagor with the bank
Mortgager and a third party.
and another third party, where there is an injunction proceedings, injunction order. During the pendency of the instant writ petition, the said suit was, however, dismissed for default. And the respondent bank have stated that they would be in a position to execute the deed of sale as well as also hand over the possession. However, the said suit has now been restored and the injunction order have also been restored. This court, under such circumstances, asks the learned counsel appearing on behalf of the respondent bank as to whether they would be now in a position to execute the deed of sale or as well as hand over the possession of the land to the petitioner. The learned counsel submits that in view of the interim order, so injunction order, so operational between the learned trial court in the dispute between the mortgagee and another third party, the respondent bank would not be in a position to either execute the deed of sale or hand over the possession. Under such circumstances, this court fixes this matter on 10th of September 2024. 17th of September 2024. Taking into account that an additional affidavit also has been filed, which is also filed by the respondent bank, which is yet to come on record. In the meantime, this court grants the liberty to the respondent bank to refund the amount of rupees 55 lakhs to the petitioner, taking into account that the petitioner is a senior citizen. 55 lakhs to the petitioner. It is, however, observed that if no payment is made during the pendency till the next date, this court shall then consider gives the liberty to refund the amount of rupees 55 lakhs to the petitioner.
Liberty may be granted if necessary to file a reply to the additional affidavit.
You file, I have not asked you not to. Madam, pay him 55. Give him the 55 and then you take the 55. We'll look into the interest later on. Yes. Yes, what is this? None appears for the petitioner on call. Okay. None appears on behalf of the petitioner on call. It is also seen that on the earlier occasion also none has appeared on behalf of the petitioner. Taking into account the above, it seems that the petitioner have lost interest in the instant proceedings. What is this matter about?
Removal of illegal street vendor.
Illegal?
Street vendor. Illegal means he has a market lordship in the Jalukbari police point area also. Some street vendors are sitting just in front of his market. That is obstructing his business. That is the allegation.
Then?
But my instruction says, lordship, we have never allowed any street vendor.
Now this has what do you call it's a virus. This virus has now gone to Jalukbari from that fancy bazaar.
He has another hotel at Beltola area. Another petition is pending.
Oh, this matter, I won't take it up. This matter, no. This person has something, some Tokyo hotel or
Okay.
something, huh?
Yes, this is
No,
Tokyo
better I
hotel.
don't take it up. Not before me. Because I did a matter against him as a lawyer. Then this person has gone to the extent that when I made submissions in the court, he files an FIR also against me for making submissions. So better I don't take up this matter. List the matter before an appropriate courts. He can go to any extent. Better. If I dismiss for default, it will become a huge. Yes, Sisi Madan Mohan Gofai. Oh, you have. You want to withdraw? Withdraw? You know case.
there are-
Locus? What
there are-
locus you have?
My lord, there are persons, my lord, having homestead land or houses also within the 500 meters.
Who? Petitioners?
Yeah, petitioners also. My
Who?
then Madan Mohan Khan also within the 500 meters of their plant. My lord. So Lordship, can I look into? I have received the instruction. These are the persons, my lord. The petitioner number 1 is a Madan Mohan Khan, 490 meters. Then petitioner 456 within 170 meters, 305, 420 meters.
Then others are there. That is the 1 to 35. They are all within the 500 meters. So I may be allowed to file affidavit.
Mr. B. Sinha, appearing on behalf of the petitioner, submits that the petitioners, most of the petitioners are resident within 500 meters of the facility, and he has got receipt. And in that regard, he would like to file an additional affidavit bringing on record that accordingly list the matter. List the matter. You are operating?
Yes.
Oh, fantastic. List the matter on 4th of November 2024.
23.
Yes, what is it? To set aside and quash the notice dated so relates to the petitioner. What is that? Where is the notice? Annexure 4
Lordship, that is at page,
page?
page Lordship 18.
Why? Why are you asking this court to set aside that?
Lordship, we are challenging the
Tell me.
Lordship, from the 0 point, it was proposed Lordship acquisition proceeding was made in both side of the road, Lordship.
Huh?
In front of the house of the present petitioner, it was made only from the right hand side. And that will seriously affect the petitioner and other people. It is a built up area. On the other hand, if it was taken in the both sides of the road, it will cause less damage to the present petitioner, and in the left hand side, there is a vacant land, Lordship. That also reduce the cost of the acquisition proceeding, Lordship. The opposite direction, it was Lordship vacant land, and there is
You submit your objections.
Lordship, I have filed a representation before the authority.
Now, did you submit your representation
Lordship.
against 3C?
Lordship.
Okay. Have you come up with 3D?
May I please, my lord, but they have submitted their representation before the wrong authority, my lord.
But now I'm asking you, did you go ahead with 3D?
Yes, Lordship, in my affidavit, Lordship, I have mentioned everything, my lord.
3D done?
Yes, my lord, here, the competent authority is Kala, Lordship, that.
3D done when?
Additional Deputy Commissioner, Lordship.
Where is the 3D?
Affidavit in paragraph number 10, Lordship.
Questions to the High Court, so the hearing was conducted where the petitioner and the petitioner said the acquisition of land pertaining to the proposed area falls in Iman, but the proposed road initiated for Iman is NHA, which is normal. The petitioner also said the proposed line is not proper as per this. I'm talking and that's it. Proposed land sponsor may be notified today. I am not. On the proposed Iman is the technique to take up the matter which is involved in the. Then what happened?
Lordship, may kindly produce paragraph 10, Lordship, that is in page number 36 of my affidavit and opposition, Lordship.
Para 10?
10, Lordship, may kindly.
Para 10 is that with the
Lordship.
statements made in the petition.
Yes, Lordship, that is the.
Para 7. Now, how is the petitioner affected with this order?
Lordship, this is the policy decision and that taken by the concerning authority, Lordship. And if he has some objection, then he has to file representation before the concerning authority.
There
I
are
think
10 of your affidavit.
affidavit, Lordship.
Now let us see what happens. Yes. Not maintainable as the deponent would like to cite following judgments of the Supreme Court and the High Court wherein similar matter relating to site plan enlightenment where interested in the enlightenment of a project is highly. No, there's no quarrel with that. I'm not on that. I'm saying whether you have gone to 3D.
Yes, Lordship, Lordship may kindly peruse next page.
Time to
Lordship,
come to page 9.
11 paragraph, my lord.
Madam, kindly come to para 9. Read it.
That the deponent would like to submit herein that as far as the situation related to the acquisition is concerned, the objections of the petitioner is still pending for disposal by the Kala Lordship. That is the competent authority for the land acquisition, my lord.
3D done. Allah.
In our affidavit, there is no mention of this 3D. But if your lordship comes to the affidavit filed by the respondent number 4,
Page 42.
no lordship, it starts from page 31, 32.
What?
In page 34, paragraph 7,
What does it say?
regarding the 3A notification of something like that.
No, 3D.
No, thereafter lordship, before
No, you are not doing that. Kindly come to page 42. Further, it is submitted that as per the aforementioned 3D
42
notification, the
lordship, it's
competent
not
authority
filed
has
by-
acquired. So, have you gone ahead with the 3D?
Lordship,
Page
Clarify.
42 lordship filed by the affidavit, lordship, it's not with me. Lord.
They have filed the affidavit. That is their
copy is not
affidavit.
with-
Page 42.
that
They say
copy is-
that about the 3D, whether the 3D has been done. Once the 3D is done, it rests upon the state. We have no business of that.
Kala is the competent.
Lordship, kindly have a look at page 36, para 9.
Huh?
Page 36, para 9. Under section 3D of the NH Act 1956 have not been notified yet.
But that I say, but come to page 42.
Okay, affidavit from John available, on number 9.
Upon the councils appearing on behalf of the NHIDCL as well as the state respondents are not aware as to whether the notification under section 3D of the National Highways Act 1956 have been issued or not. Full stop. Under such circumstances, this is the matter again on stay. Is there no stay? No stay. Early matter then. On 28th of August 2024, this court hopes and expects that the councils representing the said respondent authorities could be better prepared.
Lordship is fixing it on 28.
28th.
Lordship.
All right.
Lordship.
Lordship,
Where's the other side?
he's not appearing, Lordship. Kindly have a look on two orders passed by this court on 17th July and 28th July. Lordship,
17?
July 1st.
I passed.
Yes.
As the Amit so and so submits that in order that the year there is a direction on the so and so to designated year, be the record so and so.
And final order 28th July.
That's the matter on which that Mr. B. Gogoi, the learner, apprised this court as to whether the direction given to the food safety officer by the order has been complied or not. Okay. Mr. B. Gogoi, the learner, submits has produced the report of the analysis so that aid by the in compliance with AI and will find that the water packaging business conforms to the standards of so and so. The MBI appearing on the submit that he may be given okay. So,
So his matter, on last occasion, this I'm going to ask him, either you have to challenge this or nothing remains.
none appears on behalf of the petitioner on call. Mr. P.K. Deka appears on behalf of
Respondent 5, my lord.
respondent number 5, and Mr. B. Gogoi appears on behalf of the
Safety commissioner.
Food Safety
Commissioner, respondent.
Commissioner.
Yes, sir.
Commissioner.
Commissioner.
Full stop. This court, upon perusal of the orders dated 17/7/2023 and 28/7/2023, is of the opinion that the petitioner must have lost interest in the matter in view of the observations made therein. And as such, the petitioner has not appeared. Accordingly, the instant petition stands dismissed for non-prosecution. Yes, what is it? None appears for the petitioner.
I am appearing on behalf of Mr. A. Kakoti, petition.
Lordship,
Lordship, and I have instruction from Mr. A. Kakoti to withdraw the present writ petition. Lordship.
I have been told by Mr. Samrat Saha, Lordship, who is appearing for respondent number 4, that sale permission has already been granted, but he is on legs in another court, he told me like that. That is why most probably.
This is for the sale permission.
Yes, Lord. That is why my learned friend is most probably likes to withdraw the case, Lord.
Mr. The instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent number 4 to adjudicate the land sale permission, which the petitioner have sought for. It has been submitted by the learned counsel appearing on behalf of the respondent number 4 that the land sale permission has already been granted. The learned counsel appearing on behalf of the petitioner also agrees to the said respect and submits that he may be permitted to withdraw the instant writ petition. Accordingly, the instant writ petition having been rendered as infructuous stands closed on withdrawal.
Six.
Bora, what is this?
The petition initially, the petitioner, pursuant to a settlement and High Court's order, we are flying the buses, stopping the buses in the Dibrugarh town. Thereafter, now a impugn order has been passed, restricting us to stop. Flying is not a problem. Stopping our vehicles in the Dibrugarh town.
Inside.
Inside Dibrugarh town.
Then?
Lordship, we have moved this petition, challenging the impugn orders on the point that these are statutorily regulated. Therefore, there is a process, statutory manner in which it has to be done, and which can only be done by law. Secondly, the High Court, there is a High Court order, there is a civil court settlement, which has ended with final Lordship. Now, without modifying that order, Lordship, the respondents have, in violation of that order, passed the impugn orders. Now,
Who has passed?
There
Transport
is a
Department.
committee, the DLSC, it's a statutory 53 and 55. Now pleadings were initially complete, Lordship. Thereafter, during hearing, we also, since the congestion is also there, so initial settlement, we also.
Immediate effect to the owner driver except CNG pluses plying the association to park the vehicle at. Which order you are challenging? 50?
53 and 55.
53.
54
53
and
is
55.
different.
54 and 55.
In pursuance to the decision taken in the meeting of the District Road Safety Committee, Dibrugarh, held on Iman, in the year, henceforth stoppage of all types of buses and travelers will be immediately shifted from Dibrugarh town Murlidhar Jalan Bus Terminus Dibrugarh. Where is that?
Outside, Lordship, and it is not properly complete also. And if Lordship, if we are not given at least initial settlement was 6-7 stoppages were there. Now we are claiming only 2 stoppages.
Yes, government, what is this? Is very serious on this contention that you have not followed the due process.
But kindly come to our affidavit, page 73, para 5, para 5.
73. Yes.
5.1.
Moreover, the deponent existed that the association is not real. stoppage which is also used. So what is the method to be followed as per you?
There is a rule 73 as per the rules also, and there is a section 170. The state government has to do it. They can also delegate the authorized authority, but by a notification only. Lordship, by an additional affidavit. I have brought the rules.
Where?
Lordship, page number 64 onwards, Lordship.
Before.
Lordship, I have quoted the rules at para 5, para 67, page 67, Lordship.
Page?
67, Lordship.
60, another additional. How many additional have you? The regional transport in consultation with the local having jurisdiction over the area concerned by notification or by erection of traffic sign or may with the use of any specified place or specified class or nature as the stoppages stand or halt in place for picking up or setting down a machine by declare certain specific well, you mean to say this has to be by way of a notification?
Notification by the regional transport authority in consultation with the local authority.
Regional Transport Authority. Who is that? DTO.
DTO.
So regional in consultation with the local authority. Local authority will be the DC.
Municipal, maybe municipal.
Municipality. Have jurisdiction over the area by notification in the official gazette or by erection of traffic sign or even may either conditionally or unconditionally. So you mean to say by notification only it can be done in the official gazette?
Yes. Definitely.
Otherwise not possible.
Or by erection.
Until it is not being done, nothing can happen. Show me one notification where it is being done. Or you want this to be followed for the first time?
No, Lordship, that can be done.
Yes. What do you have to say?
Well, the District Road Safety Committee, there was mandate and directions of the Honorable Supreme Court. And as per that, Malad, in paragraph 5, we have said, Malad, I'm reading paragraph 5, Malad. Page 73, I have pointed out. The District Road Safety Committee is a committee mandated by the directions of the Supreme Court Committee on Road Safety by number so and so, dated 29/3/2022, which has been created for monitoring and enforcement of road safety across the state, in which Deputy Commissioner is the chairman of the committee. The Petitioner Association, being neither a member of the DRSC nor a regional transport authority, is trying to act as an extra legal authority to determine the routes. Furthermore, the petitioner is not a statutory authority which had been entrusted the responsibility of securing the routes of permit holders in any region in the state of Assam. In fact, the deponent begs to submit that the DRSC has not interfered with the routes.
No, but what do you reply to that? Clause 7.3.
In fact,
you say that the Supreme Court judgment has overshadowed that.
In fact, what they are doing by plying the vehicles.
No. That is another thing. What they are doing, they are putting a very point of law.
But
they are saying that there is a rule 73(1)(a) which mandates a particular thing to be done in a particular manner. What are you doing?
In my respectful submission, Malad, as on today also, there is no notification providing that they will stop these are stoppage. They will stop the buses there as on today.
So you mean to say when there is not a notification of fixing a stoppage, where is the requirement of having a notification for removing a stoppage?
Lordship, I may submit lordship on that.
71,
Lordship,
73, one of-
initially they pursuant to the court's order, they have entered into a settlement, Lordship. I have annexed a settlement, Lordship. Lordship may see the settlement. There were 6 stoppages. Now, in violation of the court's order, in violation of that settlement, they have passed this order. Not only they have violated the manner in which it has to be done, now this whole area is covered by a statute. There is no.
Where's the rule? Rule is where? Assam motor vehicle rules.
In the,
We have a Assam motor vehicle rules.
yes.
Or have you repealed it?
Act also, Motor Vehicle Act, section 170.
Find out what you have done. What is your reply? Is nothing to say about this thing. I hope. Heard Mr. B.P. Bora, the learned counsel, appearing on behalf of the Dina, the learned senior government advocate, appears for the respondent state. Various submissions have been made. Amongst the various submissions, Mr. B.P. Bora, the learned counsel, has drawn the attention to Rule 73(1)A of the Assam Motor Vehicle Rules 2003, which mandate that for having a stoppage or for removing a stoppage, there is a requirement of issuance of a notification in the official gazette. He submits nothing as such have been done prior to issuance of the impugned order. He therefore submits that the impugned order on the face of it is bad in law. Also, on the other hand, Mr. Dina, the learned counsel appearing on behalf of senior government advocate appearing on behalf of the state, submit that there is also no notification whereby the stoppage at Dibrugarh town was also notified.
These are interstate buses, not city buses.
What do you mean? That is your say. However, the learned counsel for the petitioner submits that the stoppage at Dibrugarh town is on the basis of an consent order passed by the High Court. High Court?
Yes.
By this court. Under such circumstances, this court fixes the matter again on 16th of September 2024. In the meantime, the state respondents shall apprise as to whether there is any compliance with Rule 73(1)A of the Assam Motor Vehicle Rules 2003.
In this case, I'm appearing for the respondents. I require the lordship for another 3 weeks' time to file my affidavit against the amended writ petition. Earlier affidavit was filed. But in the meantime.
Oh, that matter?
Yes.
Not yet disposed of.
Lordship, there was a hearing, but petitioner took liberty from the court to amend the writ petition. So some facts were brought.
So you want to file they have amended
Yes,
writ petition. You want to file a reply.
Yes.
The Mr. S.C. Kyle, the learned counsel appearing on behalf of the GST submits that that he requires 3 weeks' time for filing the reply to the amended writ petition. Accordingly, list the matter again on 18th of September 2024. The reply be filed. Affidavit in reply or opposition to the amended writ petition be filed by 9th of September. The petitioner, if so advised, will be at liberty to file their reply in the meantime, thereafter. The interim order passed earlier shall continue till then.
Much. My appearance made a good.
It will be given everything. Let's ask your junior to give the name.
Under petitioners belong to Chakma community, my lord.
Yes.
In Hailakandi district, my lord. We are claiming land rights, my lord, since 2018, my.
Affidavit filed?
There is also notification, my lord, in Excel 4.
Has the affidavit been filed?
They have not filed in spite of there being that.
What? Forest Department does not file affidavit?
Forest Department has not filed.
They are taking repeatedly, taking time, my. Only, my lord,
It's a new matter.
my lord, it is a matter of 23, my lord.
Notice was issued only on 2000, yeah. So, it is seen from the records that on earlier occasion, the Forest Department have been granted opportunities for filing the affidavit in opposition. However, no such affidavit in opposition has been filed. Accordingly, lists this matter again on 11th of September 2024. This court that observes that if the observes and grants liberty to the Forest Department to file their reply on or before 3rd of September. It is observed that if no affidavit is filed within the said period, the instant proceedings shall be taken up for disposal on the basis of the materials already available on the court.
Thank you.
9.
I'm appearing on behalf of.
What? Very difficult to hear you. What is your matter about?
Kindly pass over for reading.
Matter means returning from knocked down by husband at Near Road, and as a result, husband died on spot. Thereafter, the dead body so and so for conducting. And the police report reveals the man died on spot due to. And wait. Where is the police report? Report. Was knocked down by you on bearing RC number. It dispose of you. It napai. Because of that, আমি এটা order এটা দিছো মই। This is Surana's Monisha Khatun order. Disposed of. Disposing it of. You are not going to get anything. The vehicle number is an Eon vehicle. Huh?
Your Lordship, I am not in this case.
Not there, nobody appears. Okay, none appears, bully kori play order to pass for you. None appears for the petitioner, however, Mr. So-and-so is appearing, bully kori pass to what? By getting. This is a petition and so-and-so, it is covered by the judgment of the court and bench in the case of so.
Obliged.
None appears on behalf of the petitioner on call. It is also seen that on the earlier occasion also, none has appeared on behalf of the petitioner. Seen that the petitioner have lost interest in the matter, and accordingly, the petition stands dismissed for non-prosecution.
32 and 33.
I am for the respondent number 10 mark here for 1 week time to submit affidavit in opposition LLC.
What are these matters?
Regarding my lord, three laborer died in a court, my lord, which was under the implemented.
Have met with an accidental death on air while working in an underground water reservoir which have been newly constructed in by so and so. The Bilasi realization but Thakur have raised the issue of maintenance by condemning the claim for compensation. Yardstick ground would require additional evidence in the DIA. Yes, you are appealing. Who is appealing for whom? affidavits filed?
Only 10 I can leave out to this. I'm for the respondent number 10 years.
You are for respondent number 10, and it is for whose fault this person have died?
But as per FIR, my lord, lost by the executive officer, my lord, for the fault of the contractor and the.
Huh?
My lord, page 26, the FIR, lost by the executive officer.
Ah,
Here, my lord, stated, my lord, for the fault of the contractor, the. Mason
fault of the
conductor, my lord.
contractor. Who is the contractor?
So, respond number 10.
Respondent number? Fault of the contractor, and you admit that.
In the FIR, my lord.
Do you admit to the fact that it is the fault of the contractor? Okay, as per you, whose fault?
My lord, my submission is, my lord.
No, Mr. M. Hussain, I'm asking you, whose fault it is?
My lord, the person died, my lord, for the fault of all the respondents, my lord. Because, my lord, the work order itself provided, my lord, one technical personnel must be appeared on the place of work, my lord. But if,
But who is to carry out the work?
my lord, contractor,
Then go to the civil court.
my lord.
Nothing doing. Absolutely nothing. You cannot come up in a writ petition like this. You will get more money there. Here you will get not more than 25,000. You want 25,000, we can grant you. You will give 25,000? Give 25,000.
My lord, let them.
No, nothing doing.
There is a
I
judgment
am
of the-
not going to.
Yes, my lord. There is a judgment of the Honorable Supreme Court, my lord.
Which order?
Uh,
Show me.
It was, my lord, Municipal Corporation of Delhi, my lord.
Ah.
Upahar Tragedy Victim Association case.
Which one?
Upahar Tragedy Victim Association.
My
other case.
goodness.
Yes, my lord.
Upahar tragedy case, you are drawing reference to this case.
Yes, my lord.
There are limits, Mr. Counsel. Upahar tragedy, have you heard about the Upahar tragedy? Have you ever heard of what is the Upahar tragedy? Or you have only seen the law which has been declared?
My lord, in paragraph, my lord.
Forget about the paragraph. I'm asking you, do you know what is the Upahar tragedy?
There was a fire accident, my lord.
Where?
In the cinema.
Cinema hall. Then
Then,
there
my lord,
were certain mandatory requirements which were not followed by them. And therefore it became a furnace. But here it is because of a fault of a contractor in abiding by the terms of the contract. And therefore you are to claim your compensation from him. You may array the other people out there. That is a different aspect of the matter. But this is a civil dispute.
But, my lord,
If it is a case of negligence, you get it. If it is not a case of negligence, you don't get anything. And the moment he says no, the matter is over. Yeah.
but, my lord, kindly come to page 21, my lord. The
The
work
hook.
order.
Heard Mr. M. Hussain, the learned, dismiss. Liberty? No liberty.
My
You
lord,
won.
at least ask them to file affidavit. my lord.
No, nothing doing. This type of matters, no affidavit business. Don't spoil I don't believe in this environmental degradation by filing affidavits in this. Let them go and file suit
My
and
lord,
then they file.
Page
Nothing. doing.
22, my lord. Page
No.
22, condition of the work order, my lord. My lord, kindly.
If they have not complied with, let us assume they have not complied with, from whom are you going to get the money? From him, you are going to get the money.
Because, my lord, the department also liable, because, my lord, there must be a technical person should be appeared and present there, my lord. When the work is going on, my lord, but no technical person was there, my lord. That is why the.
Where is
incident
that?
has
Show me that.
My lord, page 22. Starting from page 21, my lord. Work order.
Yes, what is that?
First, my lord, page 22.
Hmm.
Serial number 12.
Third party inspection. The third party inspection agency engaged departmentally will have the liberty to inspect the executed works, construction materials, pipe minerals, etc., and all necessary support must be extended to the agency for thorough inspection of the works. Then what
Then, my
happened?
lord, serial number 18, my lord.
What is that?
Minimum one technical personnel must be deployed at the execution site who shall be created as the field level point of contact for the development authority.
Who? Who has to be appointed?
My lord, the government.
No, no, Mr. Hussain, you are reading it wrong. Minimum one technical personnel must be deployed at the execution by whom? It is by the contractor. And then who shall be treated as the field level point of contact for the departmental authority. So he will be the contact with the departmental authority. Then dismiss with cost for environmental degradation. আর দুটাতে এটা order লিখি দিছো দুটাত বেলেগ কৰি দিব। Heard Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner. Mr. Anybody serious respondent who is appearing wants to make a single submission? Who?
Appear on behalf of 11.
11? What is that 11?
Telling the word Mason.
Mason? You are appearing for 10.
10, Your Lordship. Contractor, Your
Mr.
Lordship.
Double A R Karim.
AR Karim, Your Lordship. Double A.
AR. Double A R Karim, the learned counsel appearing on behalf of the respondent number 10, and Mr. So-and-so appearing for the respondent number 11. The instant writ petition has been filed by the petitioners, who are the
But liberty may be given to that.
with cost, dismissed with cost, not necessarily filed. Cost upon the council, filed by the wife, both wives,
One mother and
filed by the mother as well as the wife of one late Syed Ali, claiming a compensation of rupees 1 crore for the loss of life of late Syed Ali on the ground of negligence. It is the case of the petitioner that the respondent number 10 have, why are you bringing 11? Why 11?
My lord, 10 and 11 engage the persons, my lord.
It is the case of the petitioner that
Lordship,
the respondent number 10 and 11
Lordship, in that context,
submits that in view of the actions of the respondent number 10 and 11, the avoidable death the husband of the late, in view, you submitted that in view of the gross negligence on the part of the respondent number 10 and 11, late Syed Ali, the death of the late Syed Ali lost his life. This court, without commenting on the merits, would like to observe that it being a case of negligence, and that too by the respondent number, by the private respondent number 10 and 11, who were engaged by the respondent authorities, The question of entertaining the instant repetition, the question of entertaining the repetition does not arise in as much as not only there would be requirement to deal with various disputed questions of facts, but also without evidence, it will be next to impossible to arrive at an appropriate compensation. It is the opinion of this court that the petitioners be well advised to approach the learned civil court of competent jurisdiction, claiming due compensation for the death of late Syed Ali. It is further observed. When did he die?
Right, but not on the same day, my lord.
Huh?
25/7/2023.
2020. 23.
7/23.
23. Okay. So we still have time. Taking into account the above, this court, while not entertaining the instant writ petition, grants liberty to the petitioner to file petitioners to approach the appropriate civil court, and the period of pendency of the instant writ petition, that is from 15/11/2023 till date, be excluded while computing the period of limitation. Mr. Hussain, where do you get these cases of long stock and barrel again, same type matters together and file it together? You can have 15.
Sir, item 33 petitioner is minor, your lordship.
Second case, the decision is minor.
Can be always done through the next guardian.
Oblige, lord.
34, 35.
Yes, madam.
35.
Northeastern Buddhist culture. How does Buddhist coming out here? The schemes are being formulated by the Union of India, so and so mission Shakti and the
Supposed to file.
Yes. What is this matter?
Well, I have received the instructions, well, the affidavit is almost ready.
Okay, file your affidavit. It's a new
need 1
matter.
week time, lord.
Huh?
I need 1 week time for bringing out it on record. Lord.
In both the matters?
In both the matters.
Both the matters similar?
Yes. Yes, Lord. Connected.
So are you filing affidavit separate?
In separately in both the cases.
Mr. Dinat, appearing on behalf of the respondent state government, submits that the affidavit would be filed within how much?
But within
2 weeks' time. First, list the matter again on 29/2024. The affidavit be filed by 9th of September 2024. The petitioner thereupon would be at liberty to file reply if so advised. In time order pastorally shall continue till then. Yes, Mr. Tuti.
Lordship of the cancellation of GST registration law.
GST registration.
Lordship has fixed on 11th of September. On Friday, Lordship has fixed similar case on 11th. Directing us to file our affidavit. Same ground, my lord, 2019 registration cancelled. Now.
No. That I fixed it on 9th of September.
Yes.
Yes.
Same ground, my lords. Yes.
You file your affidavit?
Yes, that's right. They will be on the same day, my lord, in the meantime, my affidavit.
Now, one thing is there. Now, one thing I wanted to see. Did you receive the notice?
Yes.
You have replied? You did not. Huh? And the reason for the notice and the reason for the order, is it the same?
It's same, but it's vague.
Then let them file. Mr. B. Gogoi, Learned Counsel, appearing on behalf of the respondents, the Finance and Taxation Department, seeks for some time for filing the affidavit in opposition. List the matter. When did I finally fix it? 9/11.
11/9.
11/9.
11.
11/9/2024. In the meantime, the affidavit be filed by 2nd of September.
Got
The petitioner, if so advised, would be at liberty to file the reply. I want to see only one thing. See, there are two aspects of the matter. One is cancellation of a registration. There's an appellate provision given. And the reason for cancellation is if you don't submit your returns within a particular period of time, 6 months or something to that effect. Now, is the provision of revocation to be taken so lightly? Because in the earlier case, if I remember, it was rejected in the year 2017, 19, and he filed it in the year, he filed the returns in 2024 and then filed the petition.
Also, he preferred appeal for on the ground of limitation, that was also rejected.
But immediately, not much. But here, then he submitted on 3/7, July 2024, he submitted immediately, and then he filed the writ petition. But what is the basics? Why do you reject if at the end of the day, he can very well again get a re-registration? What is the difference between it?
Actually, my lord, they don't get the benefit of input tax credit, my lord, if this cancel. Because during this period, my lord, they are in business.
But
Now-
no, understood. But taking into account the Finance Act of 2000, now which is going to come,
Yeah.
they are going to get the benefit from 17 to 21, na?
21, yes. It's still
17 to 21, if they get it, then what happens? Or this period, now from 22 to 24, they don't get it.
They don't-
So they want to revert it back to that. Okay, so
The
then
limitation
something,
is probably, my lord, 3 months and 1 month can further be extended for, my lord, revocation.
okay, we'll see. Yes, madam. So late in the day. Yes, Mr. B. Gogoi, where is he gone?
The matter relating to cancellation of registration in this case,
Same issue, my lord, we have filed a affidavit.
Lordship, they have filed the affidavit in this case. Lordship, this case is a bit different, Lordship.
Ah.
Small difference is there. Lordship, over here, Lordship, we had never received the SOCOS notice. They have uploaded in the portal. But Lordship, there were glitches on the portal. It was not opening. So Lordship, now after filing of this writ petition, they have removed the glitches and now we can see that SOCOS notice. But Lordship, Lordship, my registration was cancelled. My registration was cancelled because I did not file my returns for 6 months. But Lordship, I have made a specific statement that I am completely relying on my consultant for this. My consultant's father and mother both died during the COVID period, Lordship. So 2021, it is not 2019, it is 2021. The consultant did not file. I have proofs that I have made the payment of taxes to him. Normally, Lordship, I make the payment of taxes. He files my return and pays the taxes. This is how it is, Lordship. I have made the payment of all the taxes to him. But Lordship, because his father and mother died, he did not file the returns. Lordship, thereafter, Lordship, I did not know about the cancellation of my registration because I did not receive the SOCOS notice even. It was not opening in the portal. Lordship, in the meantime, Lordship, there was a scheme which had come. Lordship, if I may, a scheme of the government, Lordship. Because Lordship, in the whole of India, they had cancelled lakhs and lakhs of registrations at that point of time. So to deal with that situation, there was a scheme which had from the central government which had come up.
Then
It was provided.
so how many
Notification.
after how many days you approach?
I'll explain after this. Only just.
No, it's okay. How many days?
Lordship, 21, it was cancelled. Lordship, I filed in the January 2024. Lordship,
20?
yes, 2024 January. But Lordship, why did
Okay, so no, understood very well. But if you have cancelled, your registration has been cancelled, Can you submit your returns?
Returns. Lordship, they don't open the portal. They close down the portal. I cannot submit my returns, Lordship.
Then if you cannot submit the return, why didn't you look into the portal? Or ask anyway?
Lordship, I have explained it, Lordship, because thing is that, Lordship, when I purchase the GST, because I'm not a very big taxpayer, Lordship, my liability is nil. If your Lordship may see that while cancelling my registration, my liability was completely nil. Even thereafter also, my liabilities were very small. So, Lordship, I was not so much, Lordship, aware about my cancellation of registration. I came to know about the cancellation of registration only when I went to purchase some materials.
So isn't it the requirement of submission of returns every 6 months? If it is so, then why didn't you ever inquire? Did your person who was filing the returns die? How many mother father was there? Because there are 6 intervals in the meantime. Till 21 to 24, there are 3 years, which means you have to have 3 mothers. Did you have that? Then don't come up with all these excuses.
Lordship, I've taken steps in 23, Lordship.
No, I don't understand this. How do you say that a mother father has died? There cannot be 3 mothers and 3 fathers.
I'm completely, Lordship, Lordship, if your Lordship will hear for me for one more minute, Lordship, I will be able to explain the position. Lordship, may kindly see the scheme which had come up. Lordship, the scheme which says that, Lordship, the registered person may apply for revocation of cancellation of registration up to 30th of June 2023. This was the scheme which had come from the government. We said that because all over India, Lordship, there were
Did you apply?
Lordship, I had, Lordship, Lordship, this scheme was extended up to October 2023.
Where is
Lordship,
that?
Lordship, may kindly see that I have made the payment. Lordship, may come to page 51, Lordship, of my Annexure 5 series, 50-51. 49, 50, 51, Lordship, my Annexure 5 series, which is there.
Yeah.
48 is, Lordship, this is, Lordship, June 27, 2023. I had paid to my consultant to apply for the revocation of cancellation. Lordship, 3 payments are there to my.
He did not do it.
But he did not do it, Lordship. That is why, Lordship,
Okay, you must have lodged an FIR.
I have made complaints.
Where is that FIR?
I have not, Lordship, because he's a
You have
consultant.
misappropriated your money. Why haven't you filed an FIR?
I made specific.
File an FIR, then come back. What action is taken, then we restore your registration. Nothing doing. This type of action, no. One has to be very serious with this registration being cancelled. We have been given so many hearings.
Annexure 6 series.
No, nothing doing. No, you cannot come up with this Google Pay something. This Google Pay doesn't show that you are paying for that purpose. Where is it mentioned for why you are paying? No, if it doesn't show out there, where is the admission? That person has already filed an affidavit that I got every money, but I did not pay and I misappropriated. Where did he say?
Sighing away, I'm not able to get this consultant.
Then also, he has been sighing away for the last 3 years. Nothing. You have been given personal hearing also.
No, Lordship.
You can't take it.
Not personally. This person is relating to appeal, Lordship.
No, you have been given twice personal hearing.
Yes, sir, in the appeal. Lordship, twice the personal hearing was there because I filed a appeal before the appellate authority. I explained the thing.
Filed by so and so is found to have been filed after the prescribed period of 3 months from the date of the order passed by the proposed and cross the time limitation which is liable for rejection of appeal. In view of the above, the appeal is rejected on the ground that the said appeal is filed beyond the appeal. There is no period of condoning.
Lordship, there is no limitation period of condoning. Power with joint commissioner is not there, Lordship. The appellate authority power is there only with the High Court, Lordship. Lordship, I have.
What? No, there is no order. There is no power to condone.
Power to condone.
Under? This appeal is under?
107 of the GST Act. Lordship. We have to file appeal within 3 months, Lordship, and it can be extended up to 1 more month. 4 months, Lordship, thereafter they don't have a power.
So?
The appellate authority does not have a power.
And revision?
Lordship, thereafter, Lordship, because the tribunal has not been set up, thereafter you can go to the tribunal. But tribunal has not been set up, so Lordship, the High Court is the only authority which can.
Revision?
Revision is not there, Lordship. Lordship, revision like Lordship, like earlier regimes, Lordship, revision is not there. We can file rectification before the authorities for rectification of an error apparent on the face of the record.
And where is the point? No appeal shall be filed against an order under subsection 3 are equal to a where is the extended period of limitation?
Lordship,
Section 107?
107, Lordship.
The appellate may, if it is satisfied, was prevented by superior within a period of a year or 6 months, as the case may be, allow it to be presented within. Why 6 months?
Lordship, 6 months by them if they file the appeal. They can, if they file the appeal.
Then they get
sometimes
6
they
months.
also file the appeal.
You 3 months.
Yes, Your Lordship.
So there you cannot. So it has been rightly rejected.
Lordship, in the Madras High Court, Lordship, recently in such case, Lordship have said that Lordship, GST Act has not been formulated to Lordship punish somebody. It has only been enacted to collect GST. Lordship, what will they get by cancelling somebody's Lordship GST registration? Lordship, I'll Lordship rely on 2 paragraphs of this Lordship Madras High Court judgment.
What does it say?
Lordship, page 86, if your Lordship may kindly see.
Delay was more than 2 years.
Yes. COVID period was also there, so that can be 206, Lordship. 86, page 86, paragraph 206, Lordship. The reported judgment, but Lordship, I have
Page?
Page 86, paragraph 206, Lordship.
There is no page 86, it's page 73 is there. 206.
Paragraph 206.
It should be, however, remembered that the provisions of the GST cannot be interpreted in such a manner so as to debar an necessity either from obtaining registration or reviving the lapsed cancel registration, as such would not be in contrary to the Iman of the Iman. Fantastic.
Thereafter, Lordship, paragraph 210, Lordship, in my view, no useful purpose will be served by keeping this petition out of bounds. Lordship, of the GST regime under the respective GST enactments, other than to allow further leakage of revenue and to isolate these petitioners from the mainstream, contrary
All
to
GST cancellation on 11/9, na? Not
Lordship,
so soon. 11/9. This is the matter. The instant writ petition is as regards the cancellation of the GST registration of the petitioner. Taking into account the matter, similar matters are fixed on 11/9/2024. This matter on the same date.
Lordship, a similar order has been passed by the coordinate bench. I will just want only for to keep on record, Lordship.
Which one?
For Panchal Enterprise, Lordship. See, recent order, Lordship.
What did it say?
Lordship, the same date of Lordship cancellation, so cause notice as well as cancellation. And Lordship, finally, the court has said that you pay the taxes, go to the authority, and he will revoke and to file the return.
There's 4 or 5 similar orders already here.
Those are before the amnesty scheme came. I am giving the order which is very recent, even after the amnesty scheme. That June 2023.
I passed 4 days back also an order by which I have removed it. Then he made me understand.
WPC 3683.
Then he made me understand that don't give it so easily. Isn't it? I'm otherwise very lenient. So one fine day we'll do all these.
Lordship, the affidavit, they've asked me to pay everything. Only thing is that they are asking.
No,
me to
no,
pay
no. Your explanation is not good. But whatever maybe one has to. No, there's 2 aspects of the matter. That how are you agree? Means if you go for a fresh registration, what happens?
Yes, Lord. I'll be better prepared than that because Lordship, I have already given numbers to all the dealers and all my departments. Lordship, my goodwill, whatever I've earned from that GST number, that will go away. Lordship, they are asking me to make the payment till date, whatever business I've done till date, but they don't want me to take the benefit out of it. Even ITC I am entitled to claim out of the payment made. But I'll be better prepared next date. Much obliged.
Chalo. None appears on behalf of the GST. So GST.
22/7.
In that the amount of standing until has undertaken to place before certain notification which have been issued, which provide that earlier dues will have to be cleared before an appeal is filed. How the GST not? Yes.
If I got the record, but particularly that it's.
No, you said that the GST for filing an appeal, the earlier dues
Yes,
have to be
earlier,
cleared.
they have to clear the earlier dues also.
Where is the notification?
Lordship, that notification is not available in the record.
Then why did you make a submission?
No, Lordship, that is there. Lordship,
Where?
I'll pick up tomorrow.
Oh.
I'll produce tomorrow. Lordship.
Tomorrow. No, this was, you made the said submission on 27/6.
Lordship, I
You again made the same submission on 22/7. And
But
today also,
same time-
after in the month of 8 also, you say tomorrow I'll produce it.
no, Lordship,
And
what-
then when it is the same submission,
Lordship, they
how
sent-
did this court
they sent
trust?
the record, but
You gotta stay?
Lordship, no stay.
No, we stayed.
No, Lordship,
It's not done. We stay everything.
or Lordship, Lordship may
This
dispose
is
of-
not done. You have not produced it. What is the stay order you asking?
Lordship, no
Because of the inaction, we say no course of action.
the impugned order, Lordship.
We are in view of the order, no course of action. This court. It was submitted on behalf of the of Mr. S.C. Kyle on 3/6/2024. And on 27/6, wait that.
27/6/24.
27/6/2024. That earlier dues will have to be cleared before filing an appeal. And he submitted that he would produce the records, proceed with the state notification. Accordingly, this court fixed the matter on 22/7/2024. On 22/7/2024, this court also asked the GST Council to produce the same and made it clear that if the GST does not appear or produce the instructions in terms with the order, it shall be presumed that such instruction or circular does not exist. In spite of that, the GST Council have not produced any circular or instruction. Under such circumstances, this court fixes this matter again on. So we fixed it in month of June, July, August is done. Now we fix it in September, giving 1 month. On 2nd of September 2024. This court, however, hopes and expects that Mr. S.C. Kyle, the learned counsel, GST Council shall be in a position to produce such notification circular if there is any. This court, as an interim measure, directs that the respondent authority shall not take any coercive action against the petitioner on the basis of the original order in original dated 27/12/2023 till the next. Yes.
In this matter, the respondents are supposed to file affidavit.
We've written to them, my lord, we are yet to get any response from them. Lordship grants me a few weeks' time.
What?
We've written to them, my lord, for instructions in this matter.
You are also a standing counsel finance taxation.
No, my lord, I'm for the district commissioner Hojai.
What is district commissioner Hosea to do here? This is, I think, 39 is Sultan Ali.
Yes, my lord.
What
He's
does
asking for
Sultan Ali has to
settlement.
do here?
He's asking for settlement, my lord, of land.
Huh?
He's asking for settlement of ceiling surplus land, cast and ceiling surplus land.
No. What order is this then? Poor order whom I say to.
All right. Am I right?
Mr. A.K. Gupta. You are A.K. Gupta's have anything?
Copy Katogi Lordship for item number 39.
Case number is 3523/2024. So. Yeah. This matter pertains to some GST notification order.
This is about settlement, my lord.
I think has notice been issued?
In this matter?
Huh?
Yes, my lord, yes.
There is no order to that effect. Beautiful.
26/6/24.
2000, it has been submitted via no
Sultan
objection
Ali.
upon matter interim order parcel till the next date of listing. Interim order is 3235 is this. And 3253. 3253 order sheet whom said 3253.
This is 3235, my lord.
Okay. This court, upon perusal of the records, shocked to see that the instant repetition pertains to the repetition is registered as WPC number 3253 oblique 2024. 3235. 3235 oblique 2024. However, the order sheet in the instant proceedings is in respect to WPC number 3253 oblique 2024. The registry shall make necessary correction and place it before this court after
There is a
1
interim
week.
order will be continued, Lordship. There is an interim order.
Madam, this is not your case. Sultan Ali is there. Okay, there is an interim order. But that order is not there now. You have the earlier order. That order is not here. How do I know any interim order is there?
But that is 3253. This is 3235.
No, we have an order of 3235. Interim order passed earlier will continue till the next date in another matter on 26/7. But it is the
Not
earlier order, the
26/6.
first order is not there. Area. How can I pass that order now? Anyways, list this matter again on Monday. Monday, huh? Raised. Yes, any urgency? It's too late in the day. No urgency. Oh, no urgency.
Item number 41, Lordship.
What is that?
The contempt matter, Lordship.
What to do?
41. The last order of 15/7/2024, the Honorable High Court, the Honorable Court has given direction.
41. 41 to direction. Which department?
Madam, the Deputy Commissioner Nogao.
Yes, government. Yes, anybody come here.
The last occasion.
Mr. Dinath, ask Mr. Dinath to come.
Last occasion, direction given Dinath.
Dinath to come.
Lordship, respondent has filed the reply directly to the registry, Lordship. Flag A, Lordship.
A number.
41.
Where, Mr. Dinath?
When the respondent admitted, Lordship, that the amount is due, Lordship. That it is since 2013, Lordship.
You informed this court late. He was here very much. Chalo. Come ready. And put it on Monday.
Yes, Monday. Monday.
ये क्या है ये?
ठीक है दे. Monday, no? Tuesday बोलते. और Tuesday কৰি দিয়ক না, Monday মোৰ বেলেগ এটা কেছ ক্লিয়াৰ কৰি আছে 1 নম্বৰ কোৰ্টত। কৰি দিয়ক আপুনি। Forty-one.
নাম লিখে অন টাইমত মোৰ নাম লিখিব দিনা আপুনি ক'ত ফচাই আৰে দিনা থাকিব এইটো মই নহয় কালি আকৌ মোক মাতি আনিব ঘৰৰ ছোৱালী হয় সেইকাৰণে সুধিছো কেইটা টিফিন আনিছে সময় লাগে এতিয়া ঠিক নাই নহয়